have I'd like to mention this matter for listing, my lord.
What matter is that?
Matter, my lord, the second appeal, my lord. Notice issued, opposite parties appeared. And however, it was left over earlier, my lord, on 18/10/23.
Order.
My admission. Admission.
Admission? Notice admission.
Notice order. Order.
We'll have it on 20. 20.
Maybe 22nd, my lord.
20.
22nd. Apply. Yeah, these are lordship. With the consent of the other side, I beg to mention item number 15. The conducting counsel is suffering from severe illness, my lord. It is undergoing medical treatment. I only pray that the matter be passed over for.
Don't worry, it will be left over. I don't think I'll be able to complete.
Apply.
Monotaki. Yes, what was this suit for?
My lord, just suit for specific purpose of contract.
Hmm.
I am the owner defendant.
You're the vendor.
Yes. My lord, suit was defeated by the trial court, found by the first circuit court. I am against that.
Suit was dismissed and
Suit was
decreed.
decreed. First circuit court found
So,
the decree passed by
suit
the
for
trial court.
specific performance was granted.
Yes. And on the last provision, if your lordship recall, referring to paragraph 5 of the plain, I argued before your lordship that the plaintiff himself has said, suit was filed admittedly in 2001, and plaintiff himself has said in paragraph 5 of the plain that after the death of the actual defendant, now the defendant's heirs are there, on 29/7/1996, the son refused. He said the pleading is he was not willing to sell the suit land. So if the refusal is to be counted from the death of the father, the original vendor, then the suit will be burned. Then your lordship, director has to produce a copy of cross-examination of the plaintiff to see what was the cross-examination on this point. That was the stage matter where we stopped.
Yes.
Now I have got the cross-examination of PW1 typed out, although it is in vernacular. Third page, if your lordship finally comes to third page, man.
Yes.
Somewhat in the middle, my lord, there are 2-3 English words, suit land and then mutation your lordship got, my lord. Mutation
Yes,
case
mutation
number.
number.
So. Just 2 lines thereafter, my lord, towards the end. Rudresha Sharma, Rudresha Sharma. Just 2 lines below that, mutation. Rudresha Sharma 1996 সনত মৃত্যুৰ হৈছে পুলিচ কেছ দিয়াৰ পিছত মাটি মোক বিক্ৰী নকৰো বুলি ৰুদ্ৰেশ্বৰ শৰ্মাৰ পুতেকে কোৱা নাই পিছত কয় তেখেতৰ লৰাই ডাইৰেক্ট নিবিকে বুলি কোৱা নাই যদিও মোৰ সাক্ষী আৰু আৰ্টিক নট উইলিং টু চেল বুলি লিখিছো যদিও মই তেখেতৰ দেউতাকৰ মৃত্যুৰ পিছত বুলি কৈছো কিন্তু কেতিয়া কৈছিলো তাৰিখ মনত নাই answer given in cross. Well, here I would like to pause for a moment where one difficulty is there. Your lordship possibly recalls of the last week, your lordship has seen the contents of the agreement for sale. and the contents are such that your lordship also indicated that there should have been a prayer for declaration that the agreement itself is not valid. Now, my lord, if I've gone through the agreement, man, I'll show you right now to your lordship. If I argue that it is a contingent contract, in fact, it is a contingent contract, but then what is the contingency? That itself is not indicated. As a result, either I can say it is premature, or I can argue, my lord, that the suit as framed is not maintainable, because they cannot get a decree for specific for the contract, because the contract, the agreement is not a contract for sale of the land. It is a different type of contract, my lord. I'll show you, lordship, my lord. It's a contract just to allow the defendant to remain there, and in case the plaintiff the vendor sells, he will sell it. It's as if it's a right of preemption sort of thing. If he sells, he will sell it to him only. He doesn't have to pay rent, etc., etc. I'll just take a lot to the clauses of the agreement. In that view of the matter, if I argue, my lord, as I
But
indicated,
is
my
it
lord,
your pleading?
well, pleading possibly that's what that kind of pleading specifically is not there, but my submission before lordship will be, if the plaintiff himself, plaintiff is asking for a decree on the basis of an agreement, saying that there has to be he is paying for a decree for specific purpose of contract. The code below, the trial court will give him a decree of specific purpose of contract entered into between the parties. The contract itself doesn't say that the plaintiff, the defendant owner has failed to perform his part of the contract, then the court will decree. But there is no such thing as non-performance, because it is a contingent contract, and the contingency on the happening of which the defendant is to perform his part of the contract is not there at all. Plaintiff was aware of this. That is why my plaintiff has tried to make out a case, and right from the beginning his pleading is such that he says that there was a difficulty in performance of the contract, and thereafter he
No,
pleaded.
he says about the difficulty in view of the pendency.
I'm sorry, my difficulty he has said in the agreement itself there was difficulty. I mean, the plain he tried to project that the difficulty which
No,
was,
but if it is not a part of your pleading,
my lord,
can that be a subject matter of a question of law?
my lord, possibly, that's what I said, my lord, even if there is a no pleading or no defense taken by the defendant in the written statement, if my argument will be, my lord, the plaintiff himself on the basis of his government meets the plaintiff is not entitled to the decree. I need not take a defense. As your lordship is aware, my lord, if the suit is otherwise barred by limitation, even if I do not take a defense, the on report is bound
That is
to.
because of the statute mentioned in paragraph 3, section 3 of the limitation.
Yes, ma'am.
But as to whether such things are there,
My lord, I'm not really on limitation right now. My lord. What I'm saying is, my lord, suit as frame cannot be decreed when it is a suit for specific purpose of contract. Based on that agreement, a different type of suit could have been filed. But the suit for specific purpose of contract cannot be maintainable because of the contents of the agreement itself.
or in other words,
Well, I'm trying to develop an argument. It's not there. Trial court
it's okay. But in other words,
My lord,
it being a contingent contract,
my lord.
the suit for specific performance could not have been.
Your lordship is aware, I mean, no, that there are some contingent contract which where the Supreme Court says no, it can be the decree can be passed, and in the case where permission is required, permission was not obtained, then the court will say no, we'll pass a decree and we'll direct them to obtain the decree. But because
No, what you
because
say
there is no judgment, my lord, because there is a reason, my lord.
No, what you say about the specific relief act,
My lord.
I think section 20. I won't take it. Kindly come to section 22 of the contract.
Right. 22. 22 contract, my lord.
I am not wrong.
Contingent contract
No.
is 31.
Contingent contract is where?
31, my lord.
Yes. Enforcement of contract 32.
32 is enforcement.
Contingent contract to do or not to do anything.
Yeah.
If an uncertain future event happens,
Yeah.
cannot be enforced by law unless and until that
Even
happen.
happen.
If
Here,
the event becomes impossible, such contract becomes void.
I'm not arguing that impossibility of purpose.
But it is on 32(1),
Yes, ma'am.
32.
First part. And I'll show from the agreement itself. And let me kindly take a copy.
And then you may like to refer to section 14.
Yes, ma'am.
14.
Yes, the lot is correct. 14. Hello, I initially tried to argue on the basis of section 14C, the personal qualification.
This suit was filed when?
It was in filed in 2001. ma'am.
Then we have to look into the earlier act. Wait. So let us see what is your pleadings out there. Let
Fine.
us see the contract agreement.
Agreement, my lord.
Contract agreement. Okay.
Exhibit 1. If I argue this point, my lord, this limitation point I possibly cannot argue.
Why there was an amendment?
Amendment was, my lord, when I filed the written statement and I said that I made constructions, etc. of the house, they have sought for an amendment of for the purpose of adding one paragraph to say that they have made the constructions, they have dug the well, etc. That amendment.
Let us see the agreement.
Exhibit 1. Second page on what possibly we will do, madam. Search of a plot of land, and where the second party approached the first party in this regard, the first party agreed to sell the land at a price of rupees so, and the second party agreed to it and has advanced now paid rupees. So agreement is there to sell. Second, this paragraph is more important. madam. Now this indenture witnesses as follows: due to some unavoidable circumstances, it is not possible from the part of both the parties to draw up a sale deed. And due to this reason, both the parties went into enter into an agreement for this purpose with the following terms and conditions. I'll argue on that, my lord. Let me
No,
read.
before that,
My lord.
let's see the first,
But I'll read
second
first.
paragraph.
Yeah.
Where is the
Whereas
first
the
one?
first party is the absolute owner of the land mentioned fully below in the schedule, and whereas it is kept free from all encumbrances, since it is purchased and kept under the full possession of the first party without any interruption from any corner and enjoyed peacefully since the day it was purchased. And whereas for some family affairs, the first party is in need of money and wanted to sell the land, and whereas search of a plot of land, and whereas the second party approached the first party in this regard, the first party agrees to sell the land at a price of rupees so and so only, and the second party agreed to it and as advance now paid rupees so and so only to the first party. Now this indenture witnesses as follows: due to some unavoidable circumstances, it is not possible from the part of the both the parties to draw up a sale deed. And due to this reason, both the parties want to enter into an agreement for this purpose with the following terms and conditions. The first party shall sell the land mentioned herewith only to the second party and to none. It is one condition. Second one is price mentioned for the transaction of the sale is fixed one and none of the parties shall violate the condition at any time. Third is also important matter. The first party has allowed the second party to enter into the land and to erect fencing, shed, or temporary house and to make improvement of the land at the cost of the second party for the sheds or temporary houses erected on the land. Four, the second party need not pay any rent for occupying the land also. The land revenue will be paid by the first party and any tax to be paid for any construction over the land will be paid. The second party shall not make any damage of the land by digging ponds, etc. If necessary, the second party may arrange for electrification to their construction at their own cost, and the electric charge shall have to be paid by the second party. The second party may start their business at the premises mentioned herewith and may use the land as they desire, but without making any damage to the land. If the second party declines to purchase the land mentioned herewith, then the second party shall have to remove all constructions made over the land within a month from the date of expressing their unwillingness to purchase the land, and they will have to compensate for any damage done of the pond before removing their construction. The second party must allow the first party to enter into the land for inspection. The second party shall not allow any third party to occupy the land, and the second party shall live peacefully in the premises mentioned herewith.
This agreement was entered into with whom?
With the father of defendant number 3, who is contesting.
Manoj Tulda.
Manoj. Manoj Parida is the plaintiff.
Now,
My lord.
in your written statement, what is your stand?
My lord, in my written statement, since there was a dispute in between, even the plaintiff also has projected there was a dispute with regard to the possession, some third parties. In fact, even the original vendor, tribal people were there. They created some disturbance, and at that time, a 144 petition was filed.
No,
but-
understood. That's okay.
Yeah.
What is your stand in
Well,
your written?
My lord, your lordship is correct. In my written statement, my stand is slightly different. I have basically tried to project that I am in possession. You have dispossessed me subsequently,
Hmm.
and possession was never handed over to you.
Hmm.
That was basically my case. Subsequently, when I filed a counterclaim, my lord, after the plaint was amended,
Hmm.
I also made certain more statements, my lord, and there I have stated that I prayed for my title and also for recovery of possession. And as far as the agreement,
So,
Hello.
at the time of filing of the written statement by
My-
you
my-
or the counterclaim,
My-
you denied the title, denied, whatever maybe you have denied that you are
Denied,
not
I-
going to sell it to him.
yeah, in my cases of denial, I've seen.
Then under such circumstances, then doesn't he have a right of specific performance now with your counterclaim being filed?
But my counterclaim is slightly different. My counterclaim is only for declaration of title and recovery of possession and nothing. I have,
Understood.
I have
Reco-
not
Recovery of possession is there.
Well,
Why?
because I don't have possession.
Because he's in possession.
Yes.
There is no quarrel that you have handed over the possession to him.
Well, there is a point. There is
No, all these documents
no.
categorically say
I know.
we are to presume
I know.
or may this state of
agreement says that
facts
possession was given to
categorically shows that
Right.
this is a state of affairs. Existence of these state of facts were there. That there was the agreement for sale, and this agreement for sale at the time the possession was handed over. Prior to that, there was also an affidavit being filed by all the owners, which is exhibited as Exhibit 2,
Right.
which says that this Manoj Kolita was handed over. He fought everything along with the others for all these things. And as such, thereupon the agreement was entered in. Now, understood, till the earlier point of time, it is very much there. You may say that, okay, the thing is that it is no, the contingency has not happened.
Right.
But now, when you have refused, or your son,
Yes.
the son has now refused, doesn't he, his right or specific performance automatically accrues?
But here my submission will be like this. Kind of. He will have to establish his own case that he's entitled to a specific contract if I refuse.
It is now refused by you by filing your written
Well, I'm coming
statement.
there. First, he will have to establish that he is entitled to a degree of specific purpose contract on the basis of the agreement. And his cause of action will be my refusal. I am not on the cause of action part, madam. I am on the agreement which gives him a right to get a degree.
No,
My lord.
he says now they have refused in his plaint.
No, my lord. I'm possibly I have not been able to convey. I am not on that. If I refuse, that will give you a cause of action to come to court. That is there. I am not on that. What I'm saying is, my lord, the refusal is another thing. But what is he entitled to? He is entitled to a degree of specific performance of the contract. Court cannot give him a degree for specific performance of a contract which is not there. Now here is a contract which says that there is some impossibilities there. What impossibility? It is not projected in the agreement. In the plaint, he tried to say that the impossibility arose out of the disturbance created by third party.
No, 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 no,
Impossibility.
no, no, no. He doesn't say. You see, these wordings are always there in all agreement for sale for the purpose that immediately we are not in a position to execute the deed of sale, and as such we have entered into an agreement for sale. These are already there. All agreement for sale. Why there is a requirement of having an agreement for sale is always, this is the reason why, that immediately it is not possible to do that. That is why he needs money. He has been given money for all these things which has happened. He categorically alleges that you have refused now to, yes, at that point of time, he may not, if we see the language out there, that they are going to sell. But he categorically says that you have refused. to do so.
Yeah.
And when you have refused, then his right to get a specific performance of year gets triggered.
I'll at the cost of repetition, I'll refer to this second paragraph of the agreement.
I've
Which
seen that.
says, which says the difficulty was on the part of both the parties. If it was, as your lordship is indicating, if it was the difficulty of not having enough fund at that time, then it is the difficulty on his part alone, purchasers. It is a difficulty on the part of both the sides. Now, first submission is my lord. First of all, what is the difficulty?
First submission is these are things which are not there in your plea.
Written statement. No, it is not there. I'm clearly submitting. It's not there. This stand was not taken. My submission before
These
lordship,
aspects
I took a stand
on the
that should be submitted.
interpretation of that particular thing,
Minor.
where you had taken a stand to that effect in your written statement that this contract could not have been at all. That it would have been all along. You would have a right at. It's a right of like a preemption. A right of preemption, which whenever I wish to sell, I have to first offer it to him.
Right.
These are things which ought to have been there, has to have the foundation in the pleadings,
Minor, in the
foundations of the
Minor,
arguments which have been made in before the year. Without that, nothing remains.
minor, in the absence of such specific pleading in the argument, written statement, but I think I have a right in the facts of the case to argue that the second paragraph of this agreement of the second page, Mayor, says that there were unavoidable circumstances for which they are unable to, and this unavoidable circumstance was.
Don't worry, I'll take care of that, your submission.
Well,
And negate it. Yes. Now come to the question.
now, if this is this, well, then I'll have to argue the point of limit.
Yes, I'll give.
Lordship, may kindly have a look at paragraph 5 of the plea. During pendency of the state proceeding under section 145 CRPC, it was not possible to execute and register the sale. Well, here also he is indicating it is because of the pendency of the 145 proceeding that the difficulty arose, which was there in the agreement, which also is not correct, because at the time the agreement was executed, there was no dispute with regard to the possession, and all the 145 proceedings started after that. Second line is important. In the meantime, the late Rudresh Sharma expired on 29/7/1996. After the death of Rudresh Sharma, his son Kailash Sharma was not willing to sell this to plaintiff, and he had initiated false criminal cases against the plaintiff, about which the plaintiff could come to know in the year 1999, when police came to him and granted it. Well, my submission before Lordship on the point of limitation is this matter. That the court also dealt with the question of limitation, but in a different way. Court has dealt with the question of limitation with regard to the second part here, that I filed a criminal case, son filed a criminal case, that is why that amounts to refusal. Then the finding of the court, finding of fact of the court below is that he came to know about this complaint, that he has complained and he refuses to sell the land only when he was arrested. And from that date, if it is calculated, it is within time. That was the finding of the court below. My submission is, my lord, if he says that after the death of his father on 29/7/1996, the son was unwilling, that is a refusal. And from that date, if it is counted.
So we are to see paragraph 5 in parts or the total.
Even if it is taken as a whole, my lord.
Whole, then section 9 hits in
My lord,
the
I-
last line.
No, last time I read that. I'm aware that it says
And
that
that too,
agreed to sell
and
against
that too in
subsequent.
paragraph 10
My lord.
of your written statement, you deny that he has never approached you.
Yes,
So for me to deny does not arise.
I'm also aware that I've seen that. There I should have dealt with it differently. And my submission will be, if we go only to the first part, my lord, he himself is saying that after the death, he has refused. And regarding this, my lord, that subsequently he has agreed. There is
You
no-
may say one thing,
Right.
that look here, at 1996 they denied.
Right.
Thereupon, the disposal of the case happened after 3 years.
Yes.
And as such, there cannot be an extension of a period once the period have elapsed.
Well,
Stated.
That's what I'm actually trying to argue. What has happened?
When
is
was the
in
145 proceedings disposed of?
year 2000?
2000.
2000.
So 1996, then 3 years is over. Why you are not arguing on that point?
Well, at that point, I'm next arguing it.
Next arguing.
Disposed of on 25/8/2000 because
So under such circumstances,
My
it
lord.
was from 96 to 2000, almost 4 years.
yes, but that's what first I have to establish before Lordship that if the death took place on 29/7/1996, and if the plaintiff doesn't specifically say, because in the cross-examination what he did, he answered the question, but he tried to avoid, he understood by that time that there is a question of limitation. He said that when actually the son refused, I don't remember. Now, my submission will be unless he at least through evidence specifically comes up with a specific material that yes, this is the date from which actually the refusal took place, the presumption will be that from 29/7/1996 itself the refusal started.
Understood.
My lord.
You, let us go by the fact
My lord.
that it is an admitted case by the plaintiff in paragraph number 5 that on 29/7/1996,
Right.
this person, after the death of so and so, they refused. So he had notice of it. So automatically, Article 54 triggers the
Yes.
second part.
Yes.
Now, the second part,
Right.
the disposal of that case, and they say, then there was nothing out there.
No.
There was all these litigations which were being fought. It is only after the disposal he agreed. Then if the period of limitation have already expired in the meantime,
Then
once it is being triggered,
Yeah.
which is his own self-admission,
Yeah.
wouldn't that be in violation to Article 54? Because then 3 years is all over.
in between over. That's what I said yesterday when I read this first part of paragraph 5. Again, in the last part, he said that subsequently again he agreed.
So therefore,
if it's-
subsequently agreeing would not extend the period of limitation.
Exactly, my lord. And
Once the period, if the period of limitation already had expired.
my lord, Lord is absolutely correct. I'm grateful to your Lord.
But that
And-
should be your argument, I
My lord,
think.
yes. In fact,
Let us limit it.
I'm trying to, because when I saw the last part, from the first part, last part it goes against me. But for the last part, again, we'll have to relate it to the pleadings in paragraph 6. Paragraph 6 is the paragraph where he deals with the
Because
conclusion
the
of
defendants agreed to sell to the dispute after the disposal of so and so.
yeah. Now, our disposal is in, he has given in paragraph 6.
So this has
See-
been almost after 4 years.
Yes. That's what,
So that should be
My
your
lord,
argument.
my lord, absolutely.
Anything else?
That's all.
Yes. This is just a, his case, his specific case is paragraph 5. It's an admission by the plaintiff that after the death of Rudresha, he refused, and only after the disposal of the case, in the meantime, 54 period is over.
Not 50. My lord, please kindly keep the wordings, not 50. Only one person. It's only defendant number 2 was not willing to. He was not willing. He was not having intention. He never told me that no, I am not going to sell it. He was not willing. He was reluctant. He was reluctant. He was reluctant. Just he was
Let
reluctant.
us not go into this reluctant
No, no,
business
no,
and all.
no,
It is
then-
saying that he is not willing. And he had notice. The plaintiff had notice. You see,
Then
what is the requirement of
I am
54?
I'm going. Yes. Let us-
54 knows what is the
Refuse.
requirement of 54.
Regarding
54
refusal.
has two things. When the point is already given, the period is already specified, then it will go 54, the period of limitation will start. And the second part is when he has notice, then also the period of limitation will start. Here you say that the death of so and so, you have been, after the death of so and so, his son was not willing to sell the riyah to the imam, and he has intimated false criminal case against the plaintiff. Otherwise, why will you file a criminal case against the plaintiff?
I'm coming. I'm going.
When did you file a criminal case against the
I will-
plaintiff?
Sir, my sentence,
97.
my sentence,
97.
97 when?
27, 8, 97. 27, 8, 9.
Let us see what is your cross on this aspect.
Yeah, let me explain my pleading.
Please.
What is the pleading, man?
Hmm.
My pleading, they cannot break my pleading. They cannot break my sentence to arrive at different meaning. What I said that he was not willing, about which I came to know when a police came to arrest me, and that arrest was in 1999. So they cannot break my sentence to make a different meaning. I came to know, not immediately, but on the day of his father's death, about which I came to know. So my knowledge was from the on the date when the police came to and arrested me in connection with UG, and police has given me a bail also on that day itself. So let us see the sentence completely. Para 5. During present, it was not possible to execute. In the meantime, Rudra Sharma expired on 29/7/96. After death of Rudra, his son Kailash Sharma was not willing to sell the land to the plaintiff, and he had initiated false criminal cases against the plaintiff, about which the plaintiff could come to know in the 1999 when police came to him and granted him bail. So my knowledge about his intention is 1999, and this aspect has been discussed by the trial court also. It's one single sentence.
Who is this Gopal Priya?
Gopal Priya Devi,
His mother.
not mother. Gopal Priya Devi is grandmother, maternal grandmother. He had also executed similar agreement with me along with one power company.
Who is Kailash Sharma?
Sharma is one of the legal heirs of
Son of
Rudra Sharma.
Rudresh Singh. Son of
One
Rudresh.
of- Actually, there are other legal heirs also who had never refused, who has never refused to execute salary. They were always willing to execute the salary. Other legal heirs are also there. They have never come forward to contest the case. Although one WS has been filed, I don't know whose signature it contains, but they never come forward in the court. They never come to the court to adduce evidence. They have never filed appeal.
Mr. Mazumdar,
Hello.
your cross-examination has destroyed your case. After that paragraph you read,
My lord.
mutation,
Right.
read it down below.
Right.
The clarity which was missing in the plane
My lord.
is being put by way of cross-examination. Even in his examination in chief also he didn't say all this.
This, if your lordship is refer it to one sentence, নিদিও for Fatma, so sentence.
পজিশন দিলে ইমান তাৰিখে দখল দিয়া সময়ত কৈলাশ শৰ্মা আছিল
উম।
শ্বহীদ দিছিল ছেপ্টেম্বৰ মাহত কোন তাৰিখে গৈছিলো মন নাই মাটিৰ মূৰ চেলডিত কৰি দিবলৈ গৈছিলো চিন্তা কৰি চাওঁ বুলি ক'লে আকৌ ডিচেম্বৰ মাহৰ 1 তাৰিখে গলো কৈলাশ শৰ্মাই মিছবিহেভ কৰিছিল আৰু চেলডিত কৰি নিদিওঁ বুলি ক'লে
It is after the limitation period expired.
Understood. Limitation period expired, but whatever you have said,
Right.
whatever problem which was there,
Right.
is you got it out in the cross-examination and made it more clarity from his own statement.
This is with regard to the impossibility that contingency that I asked. But
Contingency is okay, but
so
this
the
is it.
limitation is concerned, my lord. Limitation is it's very clear, my lord. Yes. First of all, my lord, from 29/7/1996, there was refusal. Of course, my lord, in the same paragraph towards the end, we said subsequently, he said that subsequently he agreed. But this agreement
No, which was not so clear.
my lord,
It's made clear by in the cross by you asking all these questions. Then
and I'm coming
I
there,
can't
my lord.
help you.
That agreement, according to the plaintiff, was the agreement to sell was after the disposal of 145 proceeding. Now, 145 proceeding was disposed of on 25/8/2000, but thereafter he immediately did not approach. He approached only in the month of September 2000. So, in the meantime, my lord, the entire period has 3 years have elapsed.
No, it is not like that case where the Supreme Court judgment is given for that, this period is over. But was it within that period? Because it is so.
Right.
The reason why it is that this case
My lord,
ended on 22/7. He said something, no? Some date.
yes.
When it ended? Not 28, 5 days, another one, no? 20.
In August 2000, delivery of position was handed over to
No,
the police.
on 27/8.
27.
27/8/2000.
Yes.
So 27/8/2000, the possession was handed over.
So, my lord, 27A. Now,
So the period
27A
is not over.
27/8 was the disposal.
25/8.
25/8.
No, there is another date he said, 27. I saw it.
My lord,
here, no?
25/8. My lord, lordship, kindly see here. 25/8/2000 is the date of disposal.
Hmm.
If the possession was delivered on 27/8/2000,
Hmm.
but approach was made in September 2000. First refusal was in September 2000. He said, thereafter the plaintiff approached the principal defendant number 2 in the month of
No. It is never a question of a period being. You see, the period never. Once the period, if there is anything to that effect that it is duly given
Right.
and he has duly agreed, then the period of nine would again give you a fresh period of limitation.
No, but there was no revival within that period of 3 years. Man.
That is understood, but the problem which it is there is that here it is said
Right.
the police case was filed when?
It was
Just now he said about the date, no?
Right.
22/7.
27/8/1997.
27/8/1997 is the date on which
The FIR was.
Ah.
And he was arrested on 30/1/1999.
no, arrest is got no relation with
we are not concerned.
Right.
What is the date?
27/8/1997.
7/8/1997. And it was disposed of on 25/8/2000. Two days.
I mean, this 145 proceeding, the 145 M,
Hmm.
95. It was a case of 95. Not, no, it has not no relation with this FIR.
Yes, yes. No,
95.
this was during the lifetime of Bayer.
Yes,
And he was the person who fought all the entire litigation.
yes, yes.
He even signed the what you call the deed on behalf of the owners, the written statement. Let's see the trial court.
But start from page 44. Temptation was issue number 2. Issue number 2 discussion starts from page 47.
What had happened to the criminal case?
Acquittal. I have been acquitted. My client is.
FR was submitted, not it.
Not a part acquittal. The trial was held. After trial, acquittal was held.
And how much land was to be sold to you as per the agreement?
3 kata.
3 katha.
It is plenty.
What did the defendant 456 say? And what happened to your counterclaim?
Counterclaim was rejected.
Huh?
It was dismissed.
See, how did the trial court look? number 2.
The NTP is in the trade of buying and selling land.
So the substantial question on law number 2 does not arise.
No,
And on behalf of the plaintiff, how many witnesses were there?
There are 5 witnesses.
Five.
5 witnesses. Four. Four.
And how is Kailash Sharma related to Rudreshwar Sharma?
Son.
Only son.
There are other leaders also. 2 sons are there, other daughters are there.
Dipankar, another son. They were subsequently depleted.
In total, there are 7 legal heirs of the Rupesh Goswami.
As per you, Mr. Sharma, this paragraph 5 means that Rideshwar Sharma expired on 29/7/1996.
Mhm.
Then his son was not willing to sell, and on the other hand, in the year 1999, he filed a case.
He filed, he
He
lodged
filed a case in 97, but you came to know in 90.
a police case. He just lodged an FIR, kept it pending. Nothing had been done. No steps has been taken. That he was waiting. I am conducting 145 proceeding. Without me, 145 proceeding cannot proceed. So just kept an FIR, filed it. I do not know about the FIR. I know nothing about the FIR. I am contesting the case with him. With him. We are both cooperating in the contested case. Or his father has handed over all original documents to me. I have to produce original documents before the executive magistrate. Without me, documents cannot be produced. Without me, evidence witnesses will not come. So that's the way he is getting 25 hours. In 1999, when all the evidence are over, then only he initiated the proceeding. He had taken steps. And at that time, police came to me on due to some power only. There was an allegation that
So in 1999,
January,
when the police came on 31/99, you came to learn that he refused.
no, not refusal. Because that case
Because he
was
has filed a case against
no,
you
no,
for
the case was
fabrication.
not the case was not against the agreement. Case was with regard to one alleged power attorney, which he says that I have got one power attorney executed in his name. Fraud power attorney. About the power attorney also I did not have no knowledge. About the power attorney also I did not have any knowledge. Who executed the power attorney, how it came. I neither had any photocopy, certified copy of the power attorney, nor I had any original of the power attorney. Who manufactured it, we do not know. But on the he said that I have manufactured one power attorney in his name.
Now, in the case which he has
So-
filed in the year 1997, is the document exhibited?
That arrest document regarding arrest was exhibited.
The FIR?
FIR, I think I don't know
Okay,
whether I have to
exhibit.
cheat.
Huh?
Exhibit D,
D.
page 176.
Okay.
Now, here, if you see a contents of the FIR, it categorically says that you have been approaching him for sale, and when you refuse, he said that he will execute a deed of sale. That is his allegations in the FIR.
He never said about the agreement. He never
He
said
says-
about that there is an agreement with his father.
No, nothing
He
to
simply
that.
said
But
that-
no. Kindly see, if you have this is an exhibited document. Kindly see the FIR. Exhibits E, I suppose, 6 or E, G. G. Read exhibit G. G. See what is the exhibit G? It categorically says that he goes to you. See, read the first paragraph.
uh,
Now, if we read this with that, paragraph 5, how do you reconcile? Read this.
yes, yes, yes. Yes. So in a fire, he has mentioned that I have asked him to sell his land to me. Firstly, how can I ask him to sell the entire execute to sell it? He is not only one legal act. There are 7 legal acts. So one aspect of the matter is there. Number one. Number two, it is his FIR. Whether I have noticed about the FIR. Because
No, I'm not on the notice.
Hmm.
He said, no, now we have to read what you stated out there that he refused. He was not willing. Now you see, if we read these things,
about which I came to know when I was arrested. Before that,
It's a
I don't
different
have
thing.
knowledge.
it's a different thing. You came to know about these thing later on.
Yes.
But these, what is stated in the first paragraph of that FIR, if we read it with paragraph number 5, how do you reconcile? You can very well reconcile to the effect and say that he was not willing, as on 3/8/1997, 29/6/1997, Rudesha Sharma died. On 3/8, you went out there and this is being duly accepted by you by stating that statement. I'm coming.
That is the relate the FIR. Okay. The result of the FIR, it shows that the allegation that I approached him and he was not willing to sell the land to me. And for that, I have manufactured a power. Because he was not willing to sell the land, he refused to sell, so I have manufactured a power. That was the allegation.
Hmm.
So now,
No, his allegation is if you don't sell the land, then also I'll get the sale deed done.
okay, that is somehow I still get it. So that is his allegation. Then, my lord, so now coming to our pleading.
Hmm.
Coming to our pleading is that after death of Rudra Sharma, his son Kolastra was not willing to sell Uday Friendship, and he had initiated false criminal cases against Friendship. About which Friendship came to know in the 99 when police came to him, granted him bail. So he had filed a FIR. It's clear from the both that his intention was there that we will not get. That is clear. Then when I came to know about the intention, when the police came to me and granted a police bail. Prior to that, I did not have knowledge about that. FIR is only allegation. FIR is the only allegation. That is not true. It is part of the story in the FIR. So, from going to the FIR, when I got the police bail on 31/99, on that day, I came to know that he has got such an FIR. So, I What a meaning that he was not willing to sell the land to me. And my lord, what is his pleading? What is his reply to this paragraph, my lord? That will also be important, my lord. Paragraph 5 is WS against paragraph 5. So the plaintiff had not suppressed anything. He has written whatever was there, he has written. In January 99, police came to him. He came to know about the case, and he came to know that he has no intention to sell the land to me. So I immediately approached him, and he assured that yes, I can execute. Now, my lord, his reading may kindly be interested. That is also very relevant. Reading of the defendant in reply to my paragraph. It is also very relevant. Because in this pleading, he said that the plaintiff, after the successor, never approached the answering defendant in connection with alleged deed of agreement that to be executed by late Rutesh Sharma, as has been stated in this paragraph. He said, I have never approached him with regard to this agreement. The allegation is that I wanted to sell it from him, but he says I have never approached him with regard to this agreement. He himself clarified that I have never reached him with regard to this agreement.
So within 3199 till 2001, it was within the period of.
Up to 2002, it will be built. So it is within 2 years. So my question is that as soon as I came
Because
to
of their statement in their written statement, where they denied that fact.
89, both the Tayar statement or my statement along with the evidence is together, it comes to know that even if we take a date of knowledge, that will be 3199.
And why was the counterclaim dismissed?
Possibly because of the fact that the finding is there.
Counterclaim that you have no right title and interest.
No, that cannot be.
No, that is was your prayer in your counterclaim.
Prayer is there.
Actually, the report it is regarding right title interest that cannot be issued because if he does not have right title, they do not have right title dependent, then the specific performance does not come into that is specific performance will not. So that is the High Court said that it is not relevant. So if the defendants are not having right title interest, so specific performance will not come.
For recovery of possession.
Also,
Lahore.
One submission I have to make with regard to the statement that I made in my written statement that he never approached. It is in the context of a plea that I have taken in the written statement that there was no. I say that it was fabricated. Because there was no sentence of advance payment there subsequently incurred. I proved a document when a carbon copy of this agreement where the sentence that he paid an advance amount was not there. And there I say that he has forced this document, therefore it's not a genuine document. And I say that if there was no proper execution of a document, there is no question of he approaching me. I never said that he never approached me. There was a contract, but in spite of it, he never approached me. That I did not say.
No, in paragraph number here, you categorically stated.
My lord, I'm
And
just
let's read it. Paragraph number, reply to paragraph number 5.
my lord, I'm coming to that.
Paragraph 10.
Paragraph.
Plaintiff, after the death of so and so, never approached the answer in connection with the alleged deed of agreement said to have been executed by swear as has been stated in the said paragraph. With regard to the criminal cases filed by the plaintiff, beg to state the plaintiff manufactured a false document so and so, so and so, so and so. It's totally denied that after the intervention of AR, has been stated. So there's no denial to that effect. You have completely denied his statement that he has not approached.
That is there. But then Lordship will kindly see one thing. This FIR, I'm grateful to come to court, my lord. When the FIR says,
FIR says many things,
yes,
but why didn't you go by the FIR?
my lord, my plaintiff so far as
You
law-
should have been more clear. Yes, he has approached me on 13/8,
Lordship-
and then immediately we have done that.
my lord, Lordship is absolutely clear. When the plaintiff himself says, my lord, Lordship will go to the paragraph 5 of the claim. Only one thing is missing about the date. Lordship will kindly see, the plaintiff himself is saying that after the death of Rudresh Sharma on 29/7/1996, the defendant refused. Now the question is that date is not there as to when there was a refusal. This FIR clearly says that prior to 3/8/1997 he approached and I refused.
Then why didn't you make that statement?
I'm coming. My submission for Lordship. This document is providing the gap that is there in the plate. It is giving a specific date when he refused, 3/8/97. Now there is nothing in the cross-examination that this date he never approached me and I never refused. He never approached me.
You didn't cross-examine him on that date.
My-
That question you should have asked him.
my submission
You
because
asked him many other things, thereby fulfilling everything.
And the ideal situation that you're not seeing is not there, my lord. These questions are not there. What I am saying is, my lord, when the plane itself is very clear that his suit is barred by limitation, this all court will dismiss his suit.
What is your ground of barred by limitation?
And I have taken a plea of this.
Yes, but the reason is
Hmm.
the suit, the agreement is of 1994 and they filed the suit in 2001. Nothing else. We have not taken that ground of refusal.
But that is there. Now, what I'm saying is, my lord, from the reading of his plane, if you are not to find, let us, for the time being, keep aside the read statement. Plane itself is very clear that his suit is barred by time, whether you are not to will still degree. Plane itself is very clear. He says that there was a refusal in 1996. Only thing is there the date on which, in my humble submission, I have got two submissions here. First is in the absence of any date he mentioned, he giving anywhere, either in the evidence or in the pleading, this date of 29/7/96 is to be taken to be the date of refusal. He himself is saying, because presumption will be that from that date it is refused. Now, on top of that, one exhibit G, which is an FIR, clearly says that earlier also he approached, and 3/8/97 is the date when he last approached and he and all these things. And I'm refusing because I've brought this FIR. So from these two documents, it clearly show.
Now, can you be allowed to raise when you have completely denied that in your written statement? Problem arises there. You completely deny that statement. How do I take care of
As
that?
a
Tell me.
dependent, I'm entitled to take contradictory stand.
Absolutely, you take contradictory pleas. But isn't it the specific plea? You say that he has never approached me. On the other hand, these documents say so.
He approached.
But if I take into account this document also, this document he has noticed only on 31/2099. You couldn't prove it anywhere. Did you call the
No.
police?
No,
Did you ask him? And yeah, that is also no evidence.
Well, I'm not on the date on which he had notice of this FIR. I'm not on that. What I'm saying is, my lord, later on when this document came, this document establishes a date when there was a refusal. Now, coupled with this date and paragraph 5, it is clear that the suit is barred by limited method. He's plain, my submission will be, first submission will be, even without this FIR, from 29/7/1996, the paragraph 5 is absolutely clear. Towards the end, although he says subsequently he agreed, but this agreement was in after the disposal of 148 proceeding. The disposal was of 25/8/2000, and thereafter he further gives a date when he actually approached. That is September 2000. From that date, when the suit is clearly barred. Paragraph 5 and 6 clearly say that it is barred. This the contentions of the FIR is only an added material matter. Even otherwise, my lord, paragraph 5 and 6 are very clear that the suit is part by.
This is an appeal under section 100 of the Code of Civil Procedure, 1908,
But if the lordship helps me, there is one matter already for.
challenging the judgment and decree dated 14/7/2010 passed by the learned Civil Judge number 2, Kamrup Metro at Guwahati, entitled Appeal number 13/2009, thereby affirming the judgment and decree dated 15/12/2008 passed in title suit number 671/2006 in by the learned Munsif number 1, Kamrup Metro at Guwahati. This court, by an order dated 7/1/2011, admitted the instant appeal by formulating two substantial questions of law, which reads as under on it. At the outset, Mr. D. Mojumdar, the learned senior counsel appearing on behalf of the appellant, submits that the second substantial question of law does not arise in the instant appeal, taking into account that there was no appeal filed against the dismissal of the counterclaim by the learned trial court, and as such, the dismissal of the counterclaim having attained finality, the second substantial question of law does not arise. In that view of the matter, this court is of the opinion that the only substantial question of law which requires to be adjudicated as to whether the said substantial question of law is involved in the instant appeal is the first substantial question of law. For ascertaining as to whether the said substantial question of law arises in the instant appeal, this court finds it relevant to take note briefly the said facts which have led to the filing of the instant appeal. At the outset, it is relevant to take note of that the substantial question of law which has been formulated is a substantial question of law relating to the limitation as to whether the suit filed was barred by limitation. In that perspective, let this court take note of the facts. From a perusal of the plaint, it reveals that the predecessor in interest of the appellant, only one of the appellant, late Rudresha Sharma, who was the owner of a plot of land measuring 3 kathas in Dag number 331, covered by KP Patta number 112 of village Udalbakara, Moza Beltola, in the district of Dispur, under PS Dispur, in the district of Kamrup, had entered into an agreement dated 27/1/1994 with the respondent herein, who is the plaintiff in the suit. This agreement dated 27/1/1994 had been exhibited as Exhibit 1. This court finds it very pertinent, taking into account the substantial question of law, to take note of the contents of the said agreement. It was mentioned that the total total consideration for the sale of the suit land was rupees 80,000, and of which 40,000 was paid. It was further mentioned that due to some unavoidable circumstances, it was not possible for both the parties to draw up the sale deed, for which the parties have entered into the agreement for sale. A perusal of the clauses 1 to 11 of the said agreement do not specify as to when the deed of sale would be executed. But there are two aspects of the matter which are opposite to be taken note of. First, that late Rudreshwar Sharma agreed to sell the suit land only to the plaintiff. And that too at the same price as agreed to. The second is the possession was handed over of the suit land to the plaintiff, thereby permitting the plaintiff to erect fencing, shed or temporary house, and to make improvement of the land at the cost of the plaintiff, and in the circumstance the plaintiff, who is the second party, declines to purchase the suit land, then the second party has to remove the constructions made within a month from the date of his expressing his unwillingness to purchase the land, and also to compensate for the damage done of the pond before removing their construction. It is also seen from a perusal of the plain that a 145 proceedings was initiated during the lifetime of late Rudreshwar Sharma. In the year 1995, which was registered and numbered as 148M/1995. It is on account of the said proceedings the suit land was attached. Thereupon, during the pendency of the said proceedings, late Rudreshwar Sharma expired on 29/7/1996. In paragraph number 5 of the plain, It was categorically mentioned, inverted comma, after the death of late Rudresha Sharma, comma, his son Kailash Sharma was not willing to sell the suit land to the plaintiff, and he had initiated false criminal cases against the plaintiff, about which the plaintiff could come to know in the year 1999, when the police came to him and granted him bail. Inverted comma close. It was further mentioned that during that post the disposal, now it was also mentioned that on account of intervention of some mutual friends and well-wishers, the principal defendants agreed to sell the land as per the agreement to the plaintiff after disposal of the sale 148 state case being 148 M/1995. The same case being 148 M/1995 was decided in favor of the legal representatives of late Rudresha Sharma by an order dated 25/8/2000. There are cross claims wherein the plaintiff, there are cross claims within the plaintiff and the defendants as to who have been handed over the possession, in as much as the plaintiff claims that the possession was handed over to the plaintiff, whereas the defendant in their written statement say that the defendant number 2 was handed over the possession. Be that as it may, the plaintiff, it has been alleged by the plaintiff that the plaintiff approached the principal defendant number 2 in the month of September 2000 and requested to execute and register the sale deed in respect to the suit land in terms with the agreement, but the later refused to execute the said deed. Subsequent thereto, on 1/12/2000, the plaintiff went to the residence of the principal defendants with the balance amount of consideration and requested to execute the sale deed in terms with the agreement entered, dated 24/1/1994, entered into with late Rudresha Sharma. But the principal defendants not only refused to execute the sale deed, but also misbehaved with the plaintiff. It is under such circumstances, the suit was filed seeking specific performance of the agreement for sale, dated 27/1/1994, directing the principal defendants to execute the sale deed in favor of the plaintiff and in favor of the plaintiff for the suit land by accepting the balance amount of rupees 40,000 from the plaintiff. It has also been mentioned that in the circumstance, the principal defendants failed to execute the deed of sale, the court should execute the deed of sale. It is also pertinent to mention that alternatively, it was sought for that in the circumstance, the decree for specific performance is not granted, the amount of rupees 72,000 invested by the plaintiff with compensation at the rate of 24% per annum be decreed against the principal defendants. The defendants filed their written statement. The said suit was registered and numbered as title suit number 91/01 and filed and was filed on file A. 9/4/2001. The defendants filed their written statement wherein various preliminary objections were taken, including the preliminary objection to the effect that the suit is barred by limitation on the ground that the alleged agreement dated 27/1/1994 was executed by the predecessor of the defendant numbers 1, 2, and 3, and the suit ought to have been filed within 3 years, but was done only in the year 2001. In the written statement, the statements made by the plaintiff were denied. Whereby the possession of the plaintiff over the suit land was denied. The aspect that the plaintiff took steps in the 145, 146 proceedings was also denied. Paragraph 10 of the written statement, the defendant stated that after the death of late Rudreshwar Sharma on 29/7/1996, the plaintiff never approached the answering defendants in connection with the alleged deed of agreement. As was stated in the paragraph number 5 of the plaintiff. It was alleged that the plaintiff manufactured a false power of attorney showing to have been executed by the defendant number 2 in his favor. And the defendant number 2, having come to know about the forgery, lodged an FIR with the Panbaza PS, being Panbaza PS case number 280/97, which was under investigation, and the plaintiff was arrested and was released by bail by the police. It was totally denied that after the intervention of some mutual friends as well as well-wishers, the principal defendants agreed to sell the land as per the agreement to the plaintiff after disposal of the said proceedings under section 145 CRPC, as was stated in the paragraph. The statements made in paragraph number 6 of the plaint was also denied. Which was to the effect that a plaintiff approached the principal defendants, number 2, the defendant number 2, in the month of September 2020, and thereafter the principal defendants on 1/12/2000 for execution of the deed of sale. It is also mentioned that the question of forceful dispossession of the plaintiff over the suit land does not arise inasmuch as the defendant number 2 was in occupation of the suit land. The defendant numbers 4, 5, and 6 submitted a separate written statement in a said written statement. It was stated that the section 145 CRPC proceedings was initiated by late Rudreshwar Sharma and not by the plaintiff. And post the death of late Rudreshwar Sharma, the defendant number 2 was substituted in place of the father of late Rudreshwar Sharma. There was a denial that the legal heirs of late Rudresha Sharma were bound to execute the sale deed in favor of the plaintiff. The defendant number 2 submitted an additional written statement along with a counterclaim. On 17th of April 2002, it is very pertinent to mention that the said additional written statement was filed pursuant to the order passed by the learned trial court on 25/1/2002. The paragraph number 12 of the said additional written statement cum counterclaim is a replica of paragraph number paragraph number 10 of the original written statement. Twelve and 13 of the additional written statement are replicas of paragraph number 10 and 11 of the original written statement. In the counterclaim, the defendant number 2 sought for declaration of his right, title, and interest in the suit property with a decree of ejectment of the plaintiff from the suit land and house and delivery of the cash possession of the suit land to the defendant number 2 along with cost. In the defendant number, the plaintiff filed a written statement to the counterclaim of the defendant number 2. In paragraph number 9 of the said written statement, the statements made in paragraph number 11 and 12 of the counterclaim was denied, and the plaintiff categorically stated that the plaintiff had approached the defendant for execution of the sale deed in his favor and the plaintiff never manufactured any power of attorney as alleged by the defendant. It was further mentioned that the Panbazar police station case number 280/1997, which was initiated by the defendant number 2, had no merit. As such, no progress had been made in the said case. The record reveals that the learned trial courts has, on the basis of the above pleadings, had framed as many as 10 issues taking into account the substantial question of law so formulated. The issue number 2 related to as to whether the suit was barred by limitation. On behalf of both the plaintiff and the defendant, various the witnesses were adduced, witnesses were examined, and documents exhibited. The learned trial court, by the judgment and decree, decided judgment and decree dated 15th of December 2008, decided the state suit in favor of the plaintiff. However, dismissed the counterclaim. Pertinent herein is that the issue number 2 was decided in favor of the plaintiff, holding that the suit was not barred by limitation. The learned trial court observed that the first information report was lodged before the officer in charge of the Panbaza police station on 27/8/1997. And on the same day, the case was registered under section 420. It was opined by the learned trial court that mere lodging of an FIR may not amount to notice of the intention of the fact that a contract by the Exhibit 1 was sought to be dishonored. It was also mentioned that the plaintiff was arrested on 31/99 and he was released on the same day. It was opined that the filing of an FIR would not amount to a notice, and the plaintiff only came to learn about the refusal on 31/99. And taking into account that the suit was filed on 9/4/2001, it was held that the suit was within the period of limitation. Being aggrieved, the learned, the defendant number 2, the defendants jointly filed an appeal before the court of the civil judge number 2, Kamrup Metro at Guwahati, which was registered and numbered as title appeal number 13/2009. It was how? Appeal file. In the grounds of objection, more particularly, objection 4B, the appellant raised the issue, raised the ground that the learned trial court did not consider the averment made in the plaint, and more particularly at paragraph number 5, wherein it was categorically mentioned that after the death of Rudeshwar Sharma, his son was not willing to sell the suit land to the plaintiff. It was further mentioned in the said ground of objection that Rudeshwar Sharma expired on 27/9/1996, and the plaintiff respondent himself, and as per the averments made in the plaint itself, the refusal was made by the plaintiff appellant in the year appellant number 2 in the year 1996 itself. Therefore, the suit which was filed in the year 2001 was barred by limitation. Taking into account the limited substantial question of law which has been formulated by this court finds does not find any requirement for making reference to the other grounds of objection. The learned first appellate court by the judgment and order, judgment and decree dated 14/7/2010 dismissed the appeal. The issue number 2, it was issue number 2, na? 2, na?
Limited.
Huh?
Limited.
Issue number 2. was taken up in paragraph number 18 to 20 of the said judgment of the First Appellate Court. From a perusal of the said paragraphs, it does not seem that the learned First Appellate Court took into note the said ground of objection which was specifically taken. Rather, the learned First Appellate Court observed that on 1/12/2000, the appellant refused to perform their part of the contract, and as the suit was filed on 9/4/2001, the suit was not by limitation. Now the question therefore arises as to whether the substantial question of law which have been formulated by this court, or for that matter, the decision, the manner of deciding this appeal, deciding the issue number 2 by the learned courts below, requires any interference. The provision which is applicable in the instant case is Article 54 of the Limitation Act, of the Schedule to the Limitation Act 1963, for short, the Act of 1963. Inasmuch as the said article prescribes the period of limitation for filing a suit of specific performance of a contract, which is 3 years, and the same has to be calculated based on 2 contingencies. That is, the date fixed for performance of the contract, or if no date is fixed, the date on which the plaintiff had notice about the refusal of the performance by the defendants. The expression in inverted comma, date fixed for performance, inverted comma, close, is a crystallized notion. When a date is fixed, it means there's a definite date fixed for doing a particular act. Therefore, there is no question of finding out the intention from other circumstances. In the case of Ahmad Sahab Abdul Mullah versus Bibijan, reported in 2009 5 SCC 462, the Supreme Court observed that the expression inverted comma date is definitely suggestive of a specified date in the calendar. It is further observed in the said judgment that from a reading of the second part of Article 54 of the Limitation Act, that is, inverted comma, time from which period begins to run, inverted comma, close, it refers to a case when no such date is fixed. Or to put it differently, comma, when date is fixed, it means there is a definite date fixed for doing a particular act. The Supreme Court observed that the second part also lays emphasis on, inverted comma, when the plaintiff had noticed that performance is refused, and further observed that here also there is a definite point of time. When the plaintiff notices the refusal, it is therefore opined that in both senses, the parts refer to definite dates. And therefore, there is no question of finding out an intention from other circumstances. Paragraph number 11 and 12 of the said judgment being pertinent for the instant matter is reproduced hereunder. In the backdrop of the above, let this court take into account as to whether the suit was barred under Article 54 of the Limitation Act. Let us consider as to whether the learned courts below were justified. Under such circumstances, let this court therefore decide the said substantial question of law, which simply put would be as to whether the learned courts below were justified in deciding the issue of limitation in terms with Article 54 of the Limitation Act. Isn't it? A limitation act control. The facts above delineated in the previous segments of the instant judgment more particularly show that the plaintiff had duly admitted in paragraph number 5 of the complaint. That after the death of late Rudrasha Sharma, the defendant number 2 refused performance in the year 1990, had refused performance. And further stated that after the death of late Rudrasha Sharma, the defendant number 2 was not willing to sell the suit land to the plaintiff. And the defendant number 2 had initiated false cases against the plaintiff, about which the plaintiff would come to learn in the year 1999. When the police came to the plaintiff and granted him bail, there is no mention in the plaintiff as to when the defendant number 2, when the plaintiff had noticed that the defendant number 2 was not willing to sell the suit land. But from paragraph number 5, one can discern that it was after the death of late Rudrasha Sharma on 29/7/1996. At this stage, let this court take note of Exhibit five, the reference to which Exhibit 5 or Exhibit G?
Exhibit G.
G, na?
FIR.
Exhibit G. The reference to which the learned senior counsel for the appellant made wherein it has been mentioned this Exhibit G is the certified copy of the FIR. A Panbazar PS case number 280/1997, wherein there is an allegation amongst others, wherein it has been entirely alleged that on various dates after the death of late Rudreswar Sharma, the plaintiff approached the defendant for sale of the land. And there is a specific reference to a date being 3/8/1997. And it was stated that the plaintiff had asked the defendant, number two, that the deed of sale be executed in his favor, else he would get the deed of sale executed in his name. By other means. Okay, let me come back. Taking into account the above, the instant appeal stands dismissed.
To close my. To close. Let it close. Nothing survived.
Taking into account the above, the instant appeal stands abated. How do you know there's no legal representative?
They informed me, my lord, the relation. Earlier I know, my lord, he has no brother, their mother died when this was pending. Now, my lord, only the servant, they pick up the phone. They said nobody. And
I think I will adjourn the
other
matter.
side is, my lord, that.
I will adjourn the matter, madam, for 2 months.
Yes,
Because I can't close the appeal in this manner. Because he died on 11/4,
18 for
18/4.
after.
So even almost, it is not even a month. You still have 90 days.
Yes, my
So
lord, as you
better
wrote.
if I do
Yes,
it
yes.
now, it would
But
be proper.
Only number I am having, my lord, he was having 2 mobile. The servant, they pick up the data has died. He talked to me before Bihu. So, madam, I'm getting well, I'll come. But whatever.
Anyway,
He died.
एक ही नहीं काटी।
But
No.
I have no
Mrs.
knowledge.
Ensoikia, the learned counsel appearing on behalf of the appellant submits that the appellant that the sole appellant had expired on 18/4/2024. Taking into account the above, list this matter again. She further submits that there is no other legal representatives on behalf of the appellant to represent the estate of the appellant. taking into account the above, this court adjourns the matter till 1st of August 2024. In the meantime, the learned counsel appearing on behalf of the appellant shall take appropriate steps if in terms with Order 22, Rule 4A of the Code. Look into it, because sometimes what happens that if it is a suit for specific performance, suit for something, then in that regard, appellant died, it cannot end like that. So the court may have to appoint any person to represent.
Otherwise, my lord, the dispute is along with the cousin brothers. If he died, the cousin brothers will automatically get it, but I understand.
Understood. So whether it will be required for this court to appoint any person to represent his estate. Who was the plaintiff?
Like with the other side of other side, my lord, yeah.
They are the plaintiff. So let us have it in the 1st of August.
The earlier one visitors was appearing. Then new advocate I have not seen. So I know don't have his number.
Even the liberty to take steps in terms with Order 22.
All right.
How does the learned trial court decide the question of possession of the defendant number 1 in the counterclaim?
Trial court.
Trial court seems to have not decided the
Not-
question of possession.
Trial court was perhaps the state is we have challenged the agreement itself.
No,
We
it
don't
is
take- we
okay
don't
that he has not challenged the agreement for which.
Hmm.
But the counterclaim was for right title and interest
And possession.
and possession.
Right title interest and somehow I redundant pair. This is a pair of
No. The trial court allowed that, says that he has right title and interest.
trial court has to say because
Now, if it is being said, how can the counterclaim be dismissed?
party should have been around.
And where is the question of possession? In the case, because what happens, the problem which we are going to face is, Even if I allow your appeal,
My lord, that I
how do you take care of that situation?
here possibly, my lord, subject to what is on the book. If the plaintiff fails to prove his case of this contract, then the question will be whether his possession is a legal person. And
Then can you do it? Because your possession has been disturbed, rejected. Wouldn't the res judicata apply against you?
if it was filed by me,
Understood. Where is the trial court's observation as regards possession? Who is in possession?
Page number 7 of the assessment of the page 7, it
the second paragraph,
is not taken in case.
Yeah. Page 655. On consideration of the entire materials and the circumstances stated of the plaintiff has probabilized his case that he has been in possession of the land since the date of execution and not after 4/10/2000, the date of alleged dispossession. So the possession is there. Now, the question is, where is the rejection so far as the possession of the land is concerned? It has been decided in issue where the plaintiff has been in possession of the area. No, there is nothing decided as to whether the plaintiff is entitled to possession, defendant.
issue number 10, 10. Issue number 10 is whether the defendant number 2 is new. Defendant number 2 is to get the past possession by ejecting the plaintiff from the suit. Page 40.
No, therefore, possession, if he is held to be entitled to, he can remain in possession how? On the basis of what is his right to remain in possession?
But that is what I'm saying, my lord. Issue number 9 is framed in this way, whether the issue number 2 has right title interest over the, it has been decided at page 57.
That he has the right title.
He has.
Then
Next,
the isn't that the consequential layer? The possession, unless it is a case which comes in the performance.
but, if my case, assuming it as the case of the state, my case is that I was dispossessed subsequently in 2001.
But the trial court came to a finding of fact that
He was
he was not, on the basis of whatever documents did not look into.
Yeah.
Now, how does the first appellate court decide this?
well, for document kindly have a look at page 57. The issue number 8 and 10 have been the trial court. Trial court has said about the provision of section 34 specific.
Then, page 74, then where is the end?
Well,
End of the judgment. Issue number 9 has been decided in favor of. Kindly see the last portion.
my lord, I'm just reading that. I failed to
No, I have already held that the respondent is entitled to a decree for specific performance of the contract
Yeah.
executed by so and so. It is also proved that the respondent was put in possession of the suit land on the strength of the said agreement.
40.
For this reason, the respondent is not liable to be evicted from the suit land.
Yeah.
Under such circumstances, I fail to agree with the decision of the learned trial court so far as its decision in issue number 9.
Yeah.
But I agree with the decision of the learned trial court when the issue number 10 has been decided in the negative.
Negative.
I answer both the issues, the two issues in negative.
Yeah.
Huh? What is the two issues?
Possibly, Lord may just for this document just see the finding of the trial court at page 60.
Whether the defendant number 2 has right title and interest of the suit land.
Yeah.
Now, what do you mean by this portion? Trial court held issue number 9L.
Issue number 9A. In favor of the defendant. Page 57. Unless the plaintiff admits the title of the defendant, it will not be made.
Then why it was negative by the trial court, the first appellate court? That means you don't have title.
That's what
Then how can there be a specific performance? we keep the second issue alive, second substantial question alive, because that will be required.
Yes.
Without that, it cannot be done, because the trial court having held that you had no title, and the first appellate court having held that the first you didn't have the title, could this have been done? So don't you think that this will be a case of remand? How do this court take note of that? Take care of it. The first appellate court was undoubtedly wrong. On the question of limitation also, it had made the mistake. The
Yes, yes.
trial court was better, much better. But the first appellate court, with due respect, was absolutely wrong, because it didn't go into the question of which was in fact put as ground 4B of the grounds of objection. But how do, if it is stated out here, how can there be a specific performance, Mr.
My lord.
Sharma?
But appellate court says that. Appellate court says that alone plaintiff alone, the counterclaimant alone is not entitled to declaration of right and title upon the entire plot of land. That is his actual, that is very few answer. Because other legal heirs are there. They have not made a counterclaim that we are entitled. So alone, well, once I have filed a specific performance court type, definitely they have to right and title. So the trial court says that
No,
alone
the
he is
trial
not
court,
entitled.
the first appellate court would have made it that he had, you see, if the trial court rejects it, or the first appellate court holds that he doesn't, he rejects his entire relief, that he, the issue, takes into account that issue, number 9, and says that the plaintiff, the defendant number 2 does not have, how can you go for specific performance against defendant number 2?
But what is stated by reverting to issue, I have found that after filing WS, the respondent has amended his claim, and for that matter, appellant was allowed opportunity to file additional written statement. The appellant filed additional written, and along with it, he filed a counterclaim. The counterclaim is also signed by the appellant Kailash Sharma. Other legal heirs of late 2001 did not sign the contract. For that matter, trial court settled the additional issue involved with it. In this case, the title over the suit land yet to be transferred to the respondent. They yet to be transferred to the respondent. It is not transferred. The respondent has been occupying the suit land on the basis of an agreement executed by father of the appellant. Now the appellant is not interested in executing, so there cannot be any question of making declaration that the appellant Kailash Sharma alone is entitled to a decree as said. He is not alone entitled to it. That means
So what was the
if a
duty of
decree
the
is passed,
what was the duty of the first appellate court? It should have exercised the power under Order 41, Rule 33, and come up and say, then look at it, the decree would be there as regards all the defendants. Then only the question of specific performance can happen. If you dismiss it, wouldn't there be a adjudicator that he doesn't have title? How can you tomorrow, in view of this finding, if I don't touch it, how can you go for specific performance? You will put that objection. I don't have title. How can you go for specific performance? This was rejected.
whether in the suit, title of all the legal heirs is disputed. Nobody disputed the title of all the legal heirs. But here, what the counterclaimant wants to say that he wants to obtain a decree of declaration of title about the entire
Mr.
land
Sharma, the
alone.
law is very clear. A
Entire-
co-owner
Hmm.
can very well seek a the declaration, and a co-owner can also seek for recovery of possession.
Definitely he can seek a definitely he can seek for declaration for all the legal heirs. That yes, declaration of right and title in favor of all the legal heirs. That is correct. So, but what is his counterclaim? He declaration of right and title in favor of defendant number 2 only. His counterclaim is only in favor of defendant number 2. How can court pass decree of right and title of entire land in favor of defendant number 2 only? Of course, any co-owner can file suit for recovery of possession also. He can therefore declare of right and title in favor of all. But what he has said, he said declares of right and title in favor of defendant number 2 only. So the court said no, only against defendant number 2 cannot be allowed. It cannot be cleared. So that declaration was not made. Counterclaim may kindly be looked at.
My lord,
It is
issue
counterclaim,
is, issue is about the title of defendant number 2,
defendant 2 only.
not about the title of others.
So the court said how can defendant 2 can be given right and title upon the degree of declaration on the entire plot of land? That is correct. So, but he what is the counterclaim? He declares of right and title in favor of defendant 2 only. So the court said how can defendant 2 can be given right and title upon the degree of declaration on the entire plot of land? That is correct. So, but he what is the counterclaim? He declares of right and title in favor of defendant 2 only. So the court said how can defendant 2 can be given right and title upon the degree of declaration on the entire plot of land? pass a decree in favor of the referendum too, declaring his right that
So you should have, the court should have dismissed the counterclaim on the basis of non-joinder of necessary parties, but that was never an issue.
That was never the case of the plaintiff.
No, he has put that issue. He has raised that issue. Kindly see at this issue at paragraph 20 of his written statement. But with this, finding as regards issue number 9 and 10, how can there be a specific performance against him?
My learned friend, whatever my learned friend is saying, it's very clear. Trial court has clearly held issue number 9 in favor of the defendant number 2, holding that is entitled to the degree of right at. Now, this finding has been reversed, meaning thereby that defendant number
Without
two
an
is
appeal by him.
very
You have
clear.
not filed an appeal.
my lord,
Have you filed an appeal against
No.
it? Then how did the first appellate court reverse this?
I greatly agree with the decision of the learned trial court so far as this is number 9.
As regards issue number 9, how could the first appellate court reverse it?
not file appeal, but only finding that first of the court, actually, that should have been non-junior party. Sir.
Huh?
Non-junior party, on the point of non-junior party, that could have been rejected. And I guess that only, if the court says that only he is not alone and entitled to declaration right enter. And secondly, my lord,
No,
In
Mr.
this case-
Sharma. An appeal has to be decided on the basis of what is your grounds of objection. This is order 41 rule 3. So under such circumstances, when there is no grounds of objection as regards issue number 9, how can the trial of first appellate court decide the issue number 9 against him? Just for example,
Mhm.
tomorrow or today, this matter is not going tomorrow. If I hold that you are not entitled to specific performance, then is he not entitled to recovery?
recovery that will be subject to section 53 of the Supreme Court.
Or it is protection of possession if he prays for protection of possession. That's a
Yes.
different.
You pray for protection of
Yes.
possession is another aspect of the
Yes.
matter. I'm not on that.
Mm.
But the moment he asks for recovery, the moment you are not entitled to specific performance, you can come into 53A. 53A is a situation where he or his other persons who is claiming under him, in spite of the fact that you are willing to perform the parts of the contract, is not exercising that, and then he's trying to evict.
I'm trying to evict him,
That
then
is-
he comes to
that
the
is-
petition prayer for protection of possession under 53A.
Yes.
That is also. And even if, let me, even if my agreement may be tampered by interest, even then I can be entitled to relief under 450A. If he has not challenged my agreement, he does not say that there is no agreement. Now they are only-
Understood.
Now they are.
No,
only-
no, can,
Limits
when
on
he has the title,
Yeah.
if he has the title, you are not entitled to specific performance. Why won't he be entitled to possession? Isn't it a title is based upon that?
In this suit, he cannot claim. There is no prayer. There is no relief sought.
No, if you go for disposing, then only I go to 53A. That is another thing. If he
I've
want to
already prayed
dispose
for a
me,
decree.
He has already paid that. You see, the trial court, the first appellate court, both the trial court went into the question that you were in possession, you were there, and believed that on the basis of the agreement you were in possession, not on the basis of subsequently, on the basis of an injunction order being violated, he went.
Hmm.
So that is the finding of fact by the trial court. Understood. The first appellate court also keeps that intact. But the first appellate court goes out there and says that look here, he is not entitled to the right title interest. Thereby, how do you exercise the power of specific performance? That is another thing. But if this finding as regards issue number 9 is wrong, and you are not entitled for specific performance, then wouldn't his right of possession come automatically out there in view of the fact you don't have a better right to remain in possession?
question has to be, that question has to be gone into. That is a debatable point. That has to be gone into.
That is the second substantial question of law.
No, that is not.
That is the second substantial question of law. Only see that. Whether the trial court, having come to a finding that defendant number 2 had title over the property in issue number 9, was justified in reversing and dismissing the counterclaim in a suit or specific performance. This is the issue number 9.
But three.
Mhm. Yeah, the point. Go to it.
Last line की लिख ले. Or he will get it done well.
My lord, whether Lordship is keeping that point for argument tomorrow?
Huh?
Whether Lordship will be keeping that point for argument tomorrow?
No. I'm finishing it now. There's
Yeah,
nothing out there.
Another thing, my lord, just I want to point out one thing. Out of the evidence of the plaintiff, he said in his evidence that it is not fact that plaintiff has visited our house on C897. That is written in FIR that I have visited his house on C897, asked him to exhibit salary. That is said. It's not a fact that plaintiff has visited our house on C897. We have not visited. That is right. I came to know about the agreement between Pfizer and Manoj Kalta for sale of Switzerland in the year 1994 after operating COVID. Then he said that it was
Where?
it is on cross examination fourth page. Cross of TW1 fourth page. It's not a fact that after death of my father, most people visited our house, and I and all dependents excluding the physically into her after recovery. It's not a fact that Monty has visited our house in 3897. Specific that he is denied.
On the other hand, this court also finds it very relevant to take note of. That in the cross-examination of the defendant witness number 1, who is the defendant number 2, he had denied that the plaintiff had visited his house on 3897. And further stated that he came to know about the agreement between his father and Manoj Kolita for sale of the land in the year 1994 after obtaining copy. Later on, he also stated that he came to know about the agreement only on 2004. Which the defendant witness number 1 again denied during his cross-examination by stating that his statement that he came to know about the agreement dated 27/1/1994 in the year 2004 is false. On the other hand, if this court takes note of the evidence, the cross-examination of the plaintiff, stated that Rudreshwar Sharma died in the year 1996. He further stated that after filing of the FIR, the defendant number 2 did not inform him that he would not sell the land. However, later on, the plaintiff stated that the son of the plaintiff, defendant, the defendant number 2 did not state that he would not sell the land. Though he mentioned in his plaint as well as also in his evidence on affidavit that the defendant number 2 told him that he was not willing to sell. The plaintiff further stated in his cross that he did not remember when he went to meet the defendant number 2 after the death of late Rudreshwar Sharma. From the above evidence, if taken in note of, it cannot be said that the defendant number 2 had proved that on 13/8/1997, he informed the plaintiff that he would not sell the land. He was not willing to sell the land. And accordingly, more so, in view of the categorical denial of paragraph number 5 of the plaint in the written statement. In addition to that, in his cross-examination, the defendant number 2 categorically states that a plaintiff did not come to his house on 13/8/1997, which was the date mentioned in the FIR. Under such circumstances, though this court does not conform to the manner in which the First Appellate Court dealt with the issue number 2, but is of the opinion that the issue number 2 was rightly decided by the learned trial court by holding that the suit was filed within the period of limitation. On the basis that in the year 1999, on the basis that on 31/1999, the plaintiff came to learn about the fact that the defendant number 2 had noticed that the defendant number 2 was not willing to execute the deed of sale in favor of the plaintiff. And the suit being filed on 9/4/2001 was within the period of limitation. The above, therefore, answers the first substantial question of law. What to do with the second?
Hello, regarding second method, just want to point out.
Now you should take your seat. You have nothing. You got the first one. Yes.
Second one is in view of this finding recorded by the First Appellate Court.
Why are you raising it? Don't raise that. You say that as there is no appeal filed against that. Taking into account the above, this court finding that the substantial question of law number 1 is not involved in the appeal, and the substantial question of law number 2 having not arisen in view of the fact that there was no appeal filed against the counterclaim. This court finds no grounds to interfere with the judgment and decree passed by the learned First Appellate Court dated Swen, for which the instant appeal stands allowed. Instant appeal stands dismissed, thereby affirming the judgment and decree passed in Swen. the shall return the records. They raised it. Mr. Mazumdar, your client has spoiled your case. You had a case, but you spoiled this case.
Why?
You go this way, then you are caught up with it.
And I told my client.
Huh?
I told my client. This is the sentence I told my client.
What?
Whatever code I take, I find somewhere there is some object. And
Which one?
whatever course of argument I try to develop, in after going certain extent, when I find there is an object.
You had a case.
We had,
But
on
you-
the limitation itself, we had a very good.
Huh?
On the limitation,
Absolutely. You had a very good. And the second point of the is that, but the fact that you have raised that issue in your counterclaim, the counterclaim was, yeah, the counterclaim becomes right title interest, which is there. You don't press that, no? I think not pressing is better. In fact, he should have filed a cross objection.
now I'll have to be alert if they have to be state.
That is why I sometimes tell the lawyers out there,
Alright.
asking too many questions of law will have far-reaching consequences.
Very difficult from this point of view. One to be very, very clear about the scheme of his cross agreement. Without knowing, simply putting questions here and there will spoil it.
And in this cross, you had filed the first appellate court ought not to have touched to issue number 9. But holding issue number 9 wrong, it becomes difficult for the people.
We'll have ramifications now.
That is the substantial justice. Yes.
Dismiss for default, Lord,
How many?
Lord, 2009, it was dismissed for,
Why?
because my Lord, I actually did not know about the dismiss for default. When they initiated the execution, my Lord, in 2021, then also they know that it was dismissed for default. That case,
Why the appellant did not know?
because my Lord, the advocate concerned, he also died, my
Who is the advocate?
Lord, in Jorhat, my Lord, he is from Jorhat, my Lord. He conducted the case. So, my Lord,
Then they filed objection.
No, Lordship. I am for the respondent number 1. However, I have returned a brief, Your Lordship. This is the
Yes.
case, Your Lordship. Your Lordship have decided to restore and then again.
No.
dismiss.
I will dismiss it here and also touch on the merit so that we put a proper death nail to this litigation. This is an application under Section 5 of the Limitation Act 1963 for condoning the delay of 3,978 days in filing the restoration application for restoration of the accompanying second appeal being RSA number 42/2005. From a perusal of the records of RSA number 42/2005, it reveals that on 13/4/2005, this court admitted the instant appeal, the accompanying appeal, by formulating two substantial questions of law, which reads as under 1 and 2. Pursuant thereto, on the basis of an order passed in Miss case number 2701/2001, wherein the appellant sought for an early disposal of the second appeal. This court, by an order dated 26/11/2008, directed the accompanying second appeal to be listed for hearing expediency. And in the second appeal, on the same date, an order was passed directing listing of the matter in the end of January 2009. It is not known as to whether the said appeal was listed in the month of January 2009. But when the matter was listed on 24/3/2009, as none appeared, the appeal was dismissed for default. After almost 12 years, the instant application has been filed for condoning the delay of 3,978 days, along with an application for restoration under Order 41, Rule 19, which have been registered as IAC 1931/2021. The explanation so provided is that the applicants were under the impression that the RSA was pending. And was not informed by the council. And it was only on 26/2/2021 when two officials of the respondent number 1 and the respondent number 1 went to the residence of the applicants and tried to take possession of the suit land on the basis of a possessory warrant issued by the learned Munsif number 1 Jorhat. They made inquiry and came to learn that the RSA number 42/2005 was dismissed for default. by the order dated 24/3/2009. The blame made in the instant application is upon the lawyer. On the ground that the said application, that the lawyer, one, R.P. Dhar, since deceased, did not inform the applicant. This court have duly perused the said application and also heard the learned counsels appearing on behalf of the parties. In a recent judgment, the Supreme Court recently in the case of Pathabati Subba Reddy died by LRs and others versus Special Deputy Collector LA. After making a copious detail of the various earlier judgments, spelled out the principles as to when the delay can be condoned. Paragraph number 26 of the said judgment contains the said principles reported in it today, 2024 SCC Online SC 513. From a perusal of the above quoted paragraph of the said judgment, it would be seen that the Supreme Court categorically observed that the provisions of the Limitation Act 1963 has to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. It was further observed that in order to advance substantial justice, though liberal approach, justice-oriented approach or cause of substantial justice may be kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. It was further observed that even when a sufficient cause has been explained, is established. But when there is an inordinate delay, negligence and want of due diligence, the discretionary power to condone the delay should not be exercised. In the backdrop of the above, if this court takes note of the facts as stated here in above, it would be seen that on one hand, the applicants shows an urgency in the disposal of the appeal by filing a miss case number 2701/2008. Stating inter alia that the matter requires an early disposal. On the ground that the dispute has been pending since 1998. And on the basis of which this court passes an order on 26/11/2008, directing the registry to list the matter in the month of January 2009. Thereupon, the applicant does not appear when the matter is listed. It may be that for some circumstances, the appellant may not have appeared. The counsel for the appellant may not have been able to appear. But the question arises as to whether the appellants at all were diligent enough, taking into account that on one hand, they were seeking an early disposal of the regular second appeal, and on the other hand, were sleeping for a period of 3,900 and 78 days of sleeping for almost 11 years. The said explanation, in the opinion of this court, does not seem to be at all bona fide. In addition to this court also takes note of next slide. As to whether the substantial questions of law so formulated by this court on 13/4/2005 at all are involved in the instant appeal. Although it is not the requirement to do so while deciding an application for condonation of delay, but taking into account that there has been an allegation made against the lawyer, which this court does not encourage, taking into account that the legal profession is a noble profession. The said substantial questions of law are being taken up, are being taken up as to whether, are looked into as to whether the same are involved in the instant appeal. The first substantial question of law is as to whether the learned court erred in law in decreeing the counterclaim of the suit which is beyond the pecuniary jurisdiction of the court. The counterclaim has been valued at rupees 21,000, and the pecuniary jurisdiction of the said court was up till 25,000. Under such circumstances, the said substantial question of law does not at all arise. The second substantial question of law is whether the findings of the court below are vitiated by perversity as regards the finding on adverse possession. This court have taken note of. You are the defendant. Plaintiff. Plaintiff.
Plaintiff.
You filed a suit for right title interest on the basis of adverse possession. This court duly takes note of. That the said suit was filed by the plaintiff by claiming right title in interest on the basis of adverse possession. At this stage, this court finds it very pertinent to observe that in a recent judgment of the Supreme Court in the case of M. Radhesh Shyamlal versus Sandhya, reported in 2024 SCC Online SC 31A. The Supreme Court had observed as to how a plea of adverse possession can be proved. It was observed by the Supreme Court in the said judgment. That the party, by pleading adverse possession, seeks to defeat the rights of the true owner. And therefore, there is no equity in his favor. After all, the plea is based on continuous wrongful possession for a period of more than 12 years. And therefore, the facts constituting the ingredients of adverse possession must be pleaded and proved by the plaintiff. What is required to be pleaded and proved have been enumerated in paragraph number 12 of the said judgment, which is reproduced hereinunder. In the backdrop of the above, it would be seen from the above principles of law, if applied to the facts of the instant case, it would be seen that it was only in the month of December 1997 the defendant had approached the plaintiff to vacate the suit land. And thereupon, upon making inquiries, the plaintiff could come to learn that the defendant had purchased the suit land on the basis of a deed of sale bearing deed number 882 dated 4/3/1977. It was only on the basis that the defendant, the plaintiff, have been in long continuous possession that the plaintiffs had filed a suit for declaration of right title and interest on the basis of adverse possession without taking into account that the adverse possession has to be claimed against the true owner, and the said possession has to be for a period of 12 years, and the said adverse possession should be for a period of 12 years against the true owner. On the basis thereof, on the basis of the pleadings made in the plaint itself, there is no case made out by the plaintiff for adverse possession. The learned First Appellate Court, Trial Court as well as First Appellate Court have duly taken note of the said aspect of the matter, and including the evidence on record. Under such circumstances, the second substantial question of law is also not involved. Considering the above, that the delay in filing the application for restoration is on the face of it suffers from negligence, lack of diligence, and does not seem to be bona fide. This court is not inclined to condone the delay of 3,978 days in preferring the instant application, accompanying application for restoration of the appeal. Considering the above, the instant application stands rejected. I cannot. I know. What are these small I substitution? Done substitution. These are disposed of, no? Okay. 8191 of 2021. Economic report in view of the fact that the look at the application of 807 of 2021 has been rejected by holding that the delay cannot be condoned in filing the instant application. The instant application being barred by limitation is dismissed. Only one counsel.
When we try to start the copy of this,
No. SN Tamuli, PK,
we have
this is
put
for
a
respondent. Who has filed the Wakalatnama for the petition?
it will be
Shashanka Dasgupta, Mitu Dasgupta. Which is the order?
Lordship,
You are challenging. Come this way.
Lordship order. We are praying for modification of the order, that is Annexer 2 and the in the
Annexer 7.
Annexer 7.
Why?
Because this order was salient and this was stayed by this honorable court. Now problem is that the petitioner will be
Paid, but then also you are directed to pay.
I am getting the monthly maintenance, but the 50% amount that was directed for payment.
You are
that
the
has been
wife.
stayed. Yes, Lordship.
Then you filed an application. Who filed an application?
Lordship, that application was filed by the wife. That is,
Stating-
I have filed an application before trial court, praying for giving the claiming a part of the pensionary benefit that is due to the petitioner, because he is going to retire in this month and he is an employee of ONGC. There is no provision for monthly pension. So I am under apprehension that he may not pay the monthly maintenance to me thereafter. That is why, because he left us and started living in with another woman. And then this was passed and this impugned order was passed directing the ONGCL authority
How much you are getting?
Lordship 30,000 per month.
You are getting retirement.
No, Lordship, the retirement will be in and around crore. Because ONGC, it is a very heavy amount
No,
at
no.
one time.
Monthly, how much is he getting as pension?
Lordship, he is not getting pension pro. He is due to retire this month.
Monthly, matter of monthly maintenance. I don't get it.
Lordship,
Arrange to take the first 50% of the retirement benefit the present owner to his wife, Vika Shyam, at the time it was in the present status with the he shall continue to evade the medical facility of India. Matter of the maintenance allowance of shall be considered. So this is state of
Yes.
paying you 50%.
yes, Lordship. Now we have come with a prayer for modification of that order, at least if it is not paid to us, that may be retained by the ONGCL authority till disposal of the petition.
Why the matter come up today? The petitioner is not represented, but the matter is called for. For the end of justice, the matter stands adjourned to be listed again on 29th of May 2015. If the petitioner is not represented on that day, this court shall pass appropriate order.
But can it be a 2 or 3 days ahead of that 29?
Why?
Because he is retiring on 31st, and entire retirement benefit will be disbursed on the same day.
So we'll pass that on that day, 29th.
Yeah.
This is a very small matter. This shouldn't have come up today. I don't know why they have brought it today.
Actually, we made a mention, that is why that.
You mentioned before this court.
No, Lord.
That is why. This court doesn't allow such petty matters here on these things. It is only for second appeal cannot. Don't come up with this one. 11 and 29, don't worry. It's just 2 minutes matter.
Matul.
I didn't do it today because the petitioner counsel is absent.
Matul.
We'll dismiss it on that.
Taking to the judgment of the first appellate court, my lord. First appellate court, my lord, reversed the judgment of the trial court, my lord. Munshi court, the learned and Munshi dismissed the suit of the plaintiff, my lord. My lord, first I would like to show your lordship kind attention regarding page 55 of the plaintiff. So it is a controversy case, my lord, regarding exhibit 1 and 2 till date.
Both did you file a counterclaim?
No, my lord, the WS, my lord. In the
You
WS,
are-
first I like to.
It's a suit for what?
My lord, the plaintiff suit is for declaration of right title and first position.
Then
My lord, we file a written statement, my lord, and the paragraph, page 65, our factual part is paragraph 12, my lord. We denied the allegation of the plaintiff. The defendants are local indigenous people.
what is
Permanent
the suit of the plaintiff?
plaintiff, my lord, page, my lord, 54.
You can read it?
Yes.
Read it.
My lord, paragraph, para number 1, page 55. The plaintiff's name above both company aspects of the suit. My lord, that a plot of land measuring 4 kotha 5 lesa, out of 1 bikha 0 kotha 13 lesa, covered by dark number 66, in periodic patta number 10, at Valley Chogutai Pothar, under Moja Moirabari in the district of Moringa, with the subject matter of the instead suit. The suit patta land originally belonged to one late Akash Ali, who sold land measuring 1 bikha 13
Yes,
lesa.
now what is your stand?
My lord, page 65, my lord. Page 65, my lord, paragraph 12.
Defendants are local indigenous people. Other land from between
From Ikram and
then
Soil,
somebody
they are the
pays
Pokemon
who
respondent
plan
for
from so who promised to execute the registered sale. So who is Mohammed Ikram?
my lord, Pokemon defendant number 2 and 3. My lord, Pokemon defendant number, my lord, Pokemon defendant number, my lord, 4 and
Promised
6,
to
7, 8.
execute the sale date afterwards.
The petition of the possession of the land demanded that the land by planting various land in the border and constructed dwelling of the permanent and used to live there with families to the knowledge of all people.
What is the plaintiff case?
My lord,
Plaintiff are the owner.
my lord, plaintiff, my lord, my lord, we purchased the land from Proforma defendant number 20.
How?
We verbally purchased the land. And my lord, delivered possession. We
93.
entered into the possession of the land on 2890.
Who is the owner of the land?
My lord, Proforma defendant number 20,
Not plaintiffs.
not plaintiff.
Now the plaintiff has the trial court as well as the first appellate court come to a finding that the plaintiff is the owner of the land.
My lord, in the first appellate, the holding of the first appellate court is this, my lord. Since the plaintiff purchased the land for registered sale deed, where the value is more than 100 rupees, it must be by registered sale deed. So the plaintiff purchased the land for registered sale deed. My lord, I have come first, my lord, Munshi court judgment, my lord. I support the judgment decree passed by the learned Munshi, my lord. My lord, I like to point out one thing, my lord. My lord, plaintiff purchased the land without our knowledge, my lord. We didn't know, my lord, about the any sale transaction is made between plaintiff and my original owner. We have continuously possessed for more than 14 years.
Where is the appellate court judgment?
Appellate court judgment is, my lord, that page. My lord, 6. Section 44 and 5.
Yes. This substantial question of law does not arise. Okay.
My lord, the judge called by the learned Munsif, my lord.
Munsif
I
is
support the
wrong,
judgment, my lord.
absolutely wrong.
My lord,
You have admitted in paragraph number 9 about the deed of sale being executed by the performer
that's a
defendant.
written record, my lord.
So isn't it
We
required
don't
for
know
you?
about the execution of any sale deed, my lord. As
When
per-
they say out
as-
there you are required,
My lord,
order 8 rule 3 and order 8 rule 5.
That's I want to take your lordship, my lord, regarding my lord paragraph.
Let me
5.
finish. Let me finish this small matter within 15 minutes. Let me deliver
My
that.
lord, paragraph 5 of the plate, my lord. I like to cite, my lord, that the plaintiffs are students trying higher education out of Assam by present and taking the sums of absence of the plaintiff in Assam, both the principal defendants, father and son, and cross schedule should land on 2012-2004 and constructed houses illegally, dispossessing the member of the plaintiff. My lord, in the year 2007, they have instituted my lord. At that time, my lord, their occupation was shown as students. My lord, the exhibit 2, the cell deed, my lord, that was said to have executed on 31st of December 1997, my lord. So at that time they were minor, they were not represented by guardians. My lord. Regarding fact of possession, my lord, from that point of view, whether they have possession.
Madam,
whether
let
we
us
have
assume
repossessed-
that you were in possession from 1963.
93.
I'm giving you additional 3 years, 30 years. Then also there is no case of adverse possession.
My lord, so far the possession of the plaintiff is concerned, my lord, from the evidence of PWs and DWs, my lord. PW also, my lord, PWC is the uncle of the PW.
Madam, whatever you are saying, your client should have met you at that point of time. You would have given better advice. They came very late to you when it is a thin straw now. This is an appeal under Section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 27/5/2013, passed in title appeal number 4/2011 by the Court of the Civil Judge Morigaon, whereby the judgment and decree dated 11/10/2010 passed by the learned Munsif number 1 Morigaon in title suit number 2/2007 was reversed. This court had admitted the appeal on 8/11/2013 by formulating the following question of law. The question arises as to whether the said substantial question of law so formulated by this court is involved in the instant appeal. For the said purpose, this court finds it relevant to take note of the facts in brief, which led to the filing of the instant appeal. The plaintiffs how many plaintiffs?
Two, my lord.
The plaintiffs jointly
Rather, yes.
purchased
The schedule is also defective.
a plot of land measuring 4 Kotha 5 Lecha, covered by tag number 66 in periodic patta number 10 at village Sagunbahi, Kothar, under Moja Moirabari in the district of Morigaon, Assam, from the performer defendant number 2 and 3.
My lord, just tell it, my lord, exhibit 2 is my lord, there are 4 vendors, my lord. Specific there has not been mentioned. My lord.
Huh?
The sale deed exhibit 2, by which he claims to have his possession over that particular plot of land covered by tag number 66, patta number 10. My lord, their brothers and sisters, my lord, jointly sold the land, my lord, exhibit two, my lord, and their specific share has not been mentioned, my lord. Exhibit two may kindly be looked into, my lord. Paragraph 3 of the plain. There is no specific schedule, my lord, of that particular sale deed.
Clear to? Kolkata 5 letters covered by tag number 66 in PP number 10 at village Sagunbahi, Kotar of Moriabari, Moza, along with other portions of land of tag number 65, bracket 1 bigha 2 katha 1 letter, and 2 bighas 3 katha 8 letter, covered by tag number 78 of the same periodic patta number 10 by the registered deed of sale bearing deed number 1666/97 from whom?
My lord,
Yes, you are sitting out there.
From 2, 3, 4 and 1.
Huh?
Pro forma defendant number 2, 3, 4 and 1. 1, 2,
not
3,
one, my lord,
1 also because
not one, my lord, may
paragraph 3
I
second.
purchased, yeah,
sale deed may kindly be looked into, my lord.
okay.
Not one, my lord. It's a Fatima Khatun, my lord, wife of the performer defendant number 4, not Fojila Khatun, my lord. It is disputed, my lord, exhibit 2.
They have admitted in the document, categorical admission is
No,
there.
it's a matter of record.
I purchased the sale deed from the patada number 11 and 12. That is the performer respond number 2 and 3. It has also been stated in the plaint that a performer defendant number 1 had also sold her share of land measuring 1 katha 8 lecha to the plaintiff by executing a separate deed of sale bearing deed number 1018/94 and delivered possession of the plaintiffs to the plaintiff.
My lord, I'd like to point out critical or the point.
Madam, nothing.
Sorry,
Take your seat.
sorry.
The more you say, if it goes beyond 4, 5 because of your, another 10,000 is your cost.
Sorry.
Yes, take your seat.
All right.
Yes, don't disturb me. After the purchase made by the plaintiff, as stated in the plaint, the names of the plaintiff's names were duly recorded in the patta as patta number 15 and 16 pursuant to an order passed by the circle officer Lahori Ghat on 6/3/1999. It was alleged in the plaint that the principal defendant, that is the father and the son, had encroached the scheduled land, which is a plot of land measuring 4 katha 5 lechas covered by dag number 66 in periodic patta number 10 at village Sagunbahi, Kothar under Moza Moirabari in the district of Morigaon. On 20/12/2004 and constructed 3 houses illegally by dispossessing the members of the plaintiff. Main Piley. Hey, Piley to no, Pilo. Perfect. Tightly. It was further alleged that on 6/5/2005, when the plaintiffs came to their home from outside Assam and asked the defendants as to why they constructed the houses in the scheduled land, the defendants simply answered that they would remove the houses and return back the possession of the land to the plaintiffs within a period of 8 months. However, the defendants did not vacate the possession, and accordingly, the suit was filed seeking a decree for declaring the right, title, and interest over the scheduled land, for a decree for recovery of khas possession of the scheduled land by evicting the defendants, removing the illegal structures therefrom, etc. The said suit was registered and numbered as title suit number 2/07. The defendants filed a written statement taking various preliminary objections. It was stated in the written statement that the plaintiffs never possessed the suit land in question, as they do not live in the village Moirabari or in Hagunbahi, Kothar village. It was further stated that the plaintiff never came to the possession of the suit land. The registered sale deed, the mutation, etc., were made behind the back of those defendants who were continuously possessing the suit land from 1993 by constructing dwelling houses of permanent nature. In addition to that, in paragraph number 12 of the written statement, it was stated that the performer defendant number 2 and 3 had verbally sold the suit land to the plaintiff, to the defendant number 1 and 2, and also promised that the suit land would be transferred by way of a registered deed of sale. It was also mentioned that on the basis of the verbal sale being made on 2/8/1993, the possession of the scheduled land was handed over to the defendant. And thereupon, the defendants have been possessing the said suit land. Since then, to any objection of any people or the real owner of the land, it was also mentioned that if the right existed, the same stood extinguished by Section 27 of the Limitation Act. On the basis of the above, as many as 6 issues were framed. Which included the issue as to whether the suit of the plaintiff was hit by the law of adverse possession, the learned trial court by the judgment and decree dated 11/10/2010 dismissed the suit by coming to a finding that the plaintiff failed to prove the deed of sale in the manner provided under law, and consequently also held that the suit was barred by adverse possession, was barred in view of the adverse possession of the defendants. Being aggrieved, the plaintiffs prepared an appeal before the court of the civil judge, Morigaon, which was registered and numbered as title appeal number 4/2011. The said appeal was allowed by the impugned judgment and order, judgment and decree dated 27/5/2013. By setting aside the judgment and decree passed by the learned trial court dated so and so. It is under such circumstances the instant appeal has been filed, which has been admitted by this court by formulating the substantial question of law as quoted herein above, as mentioned herein above. The substantial question of law, which I've heard Ms. P. Devi, the legal counsel, appearing on behalf of the appellant, and Mr. appearing on behalf of the respondent. The substantial question of law is as to whether the learned first appellate court was justified in rejecting the plea of adverse possession on the ground that the defendant has set up the plea of purchase of the land by a registered instrument. In other words, whether there can be an alternative plea in the written statement relating to adverse possession. The same, there is no quarrel with the proposition that an alternative plea is permissible to be taken by the defendant. But the question, however, arises as to whether the said substantial question of law is at all involved in the instant appeal, taking into account that a question of law would only be substantial if the decision made in the said question of law would have a bearing in the decision of the lease. In the instant case, though that the defendant in their written statement have claimed to be in adverse possession, a claim that they had, although in the instant case, the defendants took two pleas. First, a plea by which the suit land was transferred to them by the performer defendant number 2 and 3 by way of a verbal sale along with delivery of possession. In terms with Section 54 of the Transfer of Property Act 1882, read with Section 17 and 49 of the Registration Act 1908, such a verbal sale is not permitted. And any sale other than by way of a registered instrument would not affect the immovable property. Therefore, the first plea which have been taken by the defendants in the suit is totally misconceived. The second plea so taken is that the defendants have been in possession of the suit land since 2/8/1993. Merely being in possession of a suit land or of any land for however long would not constitute an adverse possession. The adverse possession has to be hostile, uninterrupted, and what's the other one?
Open, adverse,
Open and open
openly adverse to the original.
and open and adverse to the true owner. Not only that, the true owner has also to know that the person asserting adverse possession is adversely possessing to his interest, his or her interest. These are specific requirements which are to be pleaded and proved to claim adverse possession. In the instant case, these particulars are missing in the written statement so filed by the defendant. And as such, as there is no pleadings to the effect, the consequential, the pleadings to the effect, there can be no question of adducing any evidence. Under such circumstances, the plea of adverse possession also is totally misconceived. Consequently, as both the pleas are misconceived in the facts of the instant case, the question of law so formulated, which as already held, is not a substantial question of law. Is otherwise also not a substantial question of law involved in the instant appeal. Accordingly, this court finds no merit in the instant appeal, for which the appeal stands dismissed with cost of 25,000, of 10,000, 11,000, cost of 11,000. In addition to that, the plaintiff shall be entitled to cost throughout the proceedings.
Much of that.
10,000.
They are indigenous. They are river-eroded indigenous.
For that, you have the Assam land policy.
Much of.
Yes, what is this? 1,000. Whether on the basis of the proof facts, the learned person erred in holding the suit to be within the period of limitation. Tell me, what is the suit for?
It is a concurrent finding of defect.
What is the suit for?
Question of law, possible that
Question of law seems to be
that whether the basic a sheet of proof fact of learned appellate for the court heard in law the holding duties within the period of limitation. Only that part,
Where is the plain?
plain lordship would find. At page 7.
Suit for declaration, right title, interest, and recovery of past possession.
Possession, that is the claim, and the lordship will, if you lordship will turn to the page 11, that is pair portion, lordship will find the plaintiff pays for the decree for declaration of plaintiff right title interest after demarcating the suit plan for commission handing over the class possession to the plaintiff.
Are these related?
Yes.
Are these people related? No.
No.
Then
Plaintiff
what is
case-
your written
plaintiff-
statement?
Plaintiff case before the court is that they purchase two plot of land, adjacent to plot of land by two different persons, who is earlier owner one Nurul Nesa,
Hmm.
and thereafter they by registered sale deed they purchase the land,
Hmm.
and the defendant and your lordship was a correlated of the higher of the Nurul Nesa. They total 1 bigha of 14 lots of land was there. In the meantime, there was some acquisition is going on, and E&D acquisition, and 4 quota of land already taken by the government. And left really only 14 lots. The petitioner case is that they are when they, in their absence in 1988, the defendant encouraged some part of their land. Defendant case, appellant case before the court is filing WS says that the land possessing by us, we are possessing this land for last 30 years, and the land possessing us is not within the parameter, within the area of that deed, and it is, in fact, it is a part of the land which is acquired at the time of acquisition, part of the land. They stand, and therefore they cannot say that we have acquired, engaged the learned court when deciding the fact. First trial court lordship will find issue number 4. Issue number 4, lordship will find the decision they have taken, given findings, is page 25. First court. The
Yes,
discussion of
what is the
issue
issue
appears
of
unnecessary
limitation?
as
No,
neither
first of all,
specific
tell
pleading.
me, what is the issue of limitation?
Issue framed the lordship will find.
No, understood. What
limit.
is your ground of limitation? Because it is not there in your pleadings.
Yeah.
What is your ground of limitation?
The defendant says in the WS, defendant in WS, that we are possessing the land. If more than 30 years, the land possessing the land, the specific lordship will find in our WS lordship find page 13 lordship find. Para 5.
Hmm.
That is clear. That suit is bound by no limitation, no possessive suit land. The second one, without any obstruction from any other, more than 30 years. The children of the dependent one is 3.5 were born on the suit land now. They are registered there. In fact, land possessed by the dependent is not the land of plaintiff. Actually, the plaintiff land was within the land was acquired by the E&D department. If any portion of plaintiff land was within the possessing of the dependent, the same is barred by limitation. That was the plea taken in the WS.
Where is the plea?
Plaintiff
Paragraph. Suit is barred by limitation. The defendant number 1 possessed the suit land as a second wife of Dabur Ali and without any obstruction from any side openly for more than 30 years. The children of the defendant number 1, defendant number were born in the suit land and now they are aged. In fact, the land in possession of the defendant, not the land of the plaintiff. Actually, the plaintiff's land was within the. So, where is the question of a limitation?
that is
No case. This is not a case of adverse possession also.
No, there is no contract claim for adverse possession.
So
This is-
under what circumstances, if the courts have already come to a finding,
Yes,
there is
sure.
no adverse, you see, unless for a suit for declaration of right title and recovery of possession, there is no period of limitation.
No, no.
The period of limitation will only accrue
Right,
if you allege adverse.
right.
So understand where is the question of here? Hello. This is an appeal under section 100 of the Code of Civil Procedure, challenging the judgment and decree passed by the judgment and decree dated 7/7/2007 in title appeal number 6/2007, where the appeal filed by the appellant herein was dismissed by affirming the judgment and decree dated 4/12/2016 in title suit number 34/06. This court, by an order dated 26/3/2008, had admitted the instant appeal by formulating the following question of law. The question therefore arises, as to whether the said question of substantial question of law so formulated at all arises, is involved in the instant appeal. From the facts above mentioned, from the said question of law, substantial question of law so formulated, it is seen that the question arises is as to whether the learned first appellate court erred in holding that the suit was within the period of limitation. This court have duly taken note of the plaint, wherein it has been mentioned that the defendant number 1, 2, 3, 4, and 5 started to stay in the vacant portion of the plaintiff's land by constructing 2 temporary houses from the month of May in the year 1988. 88 or 98? No. Hey, where's the original? Because the trial court holds it to be 98. Oh no, it is suit is of 94, na? Or 88. 88. And also constructed a cowshed near the rental houses of the plaintiff. It was also mentioned that the defendant number 6 had expanded his boundary and 1.5 years ago by constructing a house over the plaintiff's plot of land. It was therefore it is therefore the case of the plaintiff. The plaintiff has sought for declaration of right title and interest after demarcating the suit land through a commission and handing over the cast possession to the plaintiffs, and a decree for compensation in respect to the scheduled land. The defendant have filed a joint written statement, and in paragraph number 5, it was mentioned that the defendants have been residing the defendant number 1 has been possessing the suit land as a second wife of late Jabbar Ali, and without any obstruction from any side and openly for more than 30 years. The children of the defendant number 1 and the defendant numbers 3, 4, and 5 were born in the suit land, and now they are aged 30, 28, and 23 respectively. It was categorically stated that the land in possession of the defendant is not the land of the plaintiffs, and the plaintiff's land was within the land which was acquired by the E&D department. It was, in addition to that, it was stated that if any portion of the land which is being possessed by the defendant belongs to the plaintiff, the same is barred by limitation. This court is not taking up the other issues, taking into account that the substantial question of law is limited. It is seen that the learned trial court framed as many as 8 issues, of which the issue number 4 was as to whether the suit was barred by limitation. The learned trial court, in the opinion of this court, erred in deciding the issue number 4, inasmuch as the learned trial court held that the said issue was unnecessary, as there is neither any specific pleading nor there is any evidence led by the parties warranting any decision on the point. Whereas paragraph number 5 of the written statement was specific on the question of limitation. Be that as it may, the learned trial court decreed the suit in favor of the plaintiffs by granting the reliefs as sought for. In addition to also, the defendants thereupon preferred an appeal before the court of the civil judge Lakhimpur in North Lakhimpur, which was registered and numbered as title appeal number 6/2007. The said appeal was dismissed. Issue number 4 was decided again in favor of the plaintiff and against the defendants by holding that as the plaintiff had averred in the plaint that in the month of May 1988, the defendant numbers 1, 2, 3, 4, and 5 occupied the land of the plaintiff, and the defendant number 6 occupied the suit land 1.5 years prior to the filing of the suit. So the suit was brought within the period of limitation. I've heard Mr. P.P. Borua, the learned counsel, appearing on behalf of the petition appellant. Now, it is against the said finding, it is against the said judgment and decree passed by the learned first appellate court, whereby the appeal was dismissed. Judgment and decree dated 7/7/2007, passed by the learned first appellate court, by which the appeal was dismissed. The present appeal has been filed. I've heard the learned counsel appearing on behalf of the appellant, Mr. P.P. Borua, and have duly given the anxious consideration to his submissions. This court finds it very relevant to take note of that the suit which was filed was a suit for declaration of right title in interest and recovery of past possession. The suit, such a suit, in the opinion of this court, in respect to such a suit, in the opinion of this court, which is based on title, there is no limitation prescribed. However, in the case in such a suit, there is no question of any limitation, inasmuch as a suit based on title can be filed for recovery of possession at any point of time. However, if in the case the defendants pleads and proves adverse possession, the period of limitation will be 12 years. In the instant case, if this court duly takes note of the pleadings of the defendants, the same are bereft of particulars as regards of any adverse possession. Under such circumstances, the substantial question of law, in the opinion of this court, under such substantial question of law which have been formulated in the opinion of this court does not arise, for which is not involved in the instant appeal. Inasmuch as the learned trial court as well as the learned first appellate court were justified in deciding the said appeal, in passing the judgment and decree dated 7/7/2007, and more so in respect to the decision rendered in issue number 4. Accordingly, the instant appeal stands dismissed with cost quantified at rupees 11,000, which the appellant, the plaintiff, would be entitled to cost throughout the proceeding, which returned elsewhere. Any more? No more? Yes, Mr. Sheikh. You want to do it? Yes. I am.
Will your lordship take it?
For me, I always sit till 5. I'm only at here. On Thursdays and Tuesdays, I don't pressurize the lawyers.
Anyhow, my lord, some time will be taken. Some time will be taken. So it is already 4:30, my lord, better not to take.
It's okay. No one want to do it, why I would not pressurize anybody. This is at your volition. After 4:30, it is your.
Thank you, Lordship. Item 14. Defendant number 2.1 has expired as per my instructions.
Mr. Sheikh, where is he? He was here, na?
Mr. Das was there.
Mr. M.A. Sheikh is there.
I saw Mr. S. Das in the court.
Mr. Sheikh, his name is there.
Otherwise, 2.2 and 2.3 are his her legal heads. They are already on record.
So it's okay. Let it come up summarily.
Title number 3, madam.
Ah.
Title number 3.
Ah.
I paid it after 23rd.
Why?
So I got your statement is going on 20.
You don't have a case. This matter won't come up here on 16th. It won't come up. 16th there is other matters, so it may come up on 21st. Likely.
Hello, it's a concurrent finding in our favor.
Oh, why you here? You'll do it. Without the respondent, I dismiss the appeal. Where are you going?
Your Lordship, item number 11, I am for the respondent. I would like to bring to notice of this honorable court that appellant has expired on 6th April 2024.
How do you know?
I have been informed by respondent number 1.
That is what it has been mentioned. I fixed it on 1st of August. Appellant expired on 18/4/2024. Okay. So I can abate the appeal.
Yes, Your
So it has to go for abatement after only 90 days.
Lordship.
So I can't do anything. So let us I fix it on 1st of August 2020.
Apply to.
Item number 6. Date may be fixed. I have mentioned for
These matters will come up at the top of the list.
Okay.
Oh, 2012 में ओल्ड में तो एक होते की तो कोई मैं लेके हो 3 लेके हो नहीं 2 लेके 3 4 5 6 will have it on equestrian equal equestrian top of the list.